All right. Good morning, everyone. Let's try and maintain a little quietness, please. And we're going to have a busy schedule. I want to get started early if we can. And I'm going to call on Ms. Fullerton, who has a matter that she wants to bring before the committee, and that will be the first bill for us to consider. Good morning, Representative Fullerton.
Good morning. I believe that you have copies of what I'm going to say, plus a couple of support letters. Excuse me. Mr. Chairman and members of the House Judiciary Committee, I very much appreciate this opportunity to speak this morning in favor of House Bill 534, a bill I am sponsoring with your Chairman Wendell Willard and fellow members Ed Lindsay, Jay Powell, and Mary Margaret Oliver. I hope to keep my remarks to a minimum to leave time to answer any questions that you may have. While my comments will reflect that my bill has very limited application, it does touch on an important legal issue which could affect many other counties if it does not pass. I myself must profess that I am not a lawyer, although I am blessed, I think, is the right word to use with this group, to have a lawyer husband and a lawyer son. For clarification, my bill is a substitute bill in that it has been amended to reference properly the 2010 census as opposed to the 1990 census that was in the original version. This change has been made with the guidance and support of Legislative Counsel Wayne Allen. I must stress one critical point at the beginning. My Bill 534 is a bill of general legislation and not local legislation. Nonetheless, if passed as written, it will only affect the probate court of Dougherty County and none of the other 158 counties.
Ms. Fullerton, I'm going to ask, I think we understand the purpose of the bill. We're going to be on a tight schedule this morning, and we all have your comments.
All right.
What I'm going to suggest is that we understand the purpose of the bill is because Dougherty County previously would be required under the bracketing of population to have their probate judge to be an attorney also. Correct. As a qualification of office.
Right.
There's been a change in the population in the fact that Dougherty County has decreased in population since 1990, and now you fall into a different bracket category, which says that a judge of the probate court does not have to be an attorney.
Correct.
And Dougherty County would desire to have their probate judge continue to be a member of the bar, an attorney, in other words, as a part of their qualifications.
Yes, sir. So that it can be a 6.
So what we're asking to do is to bracket that by a change of the general law from what we have previously is 96,000 down to 90,000.
Yes, sir.
And we had this go through Legislative Council because of a concern about what we can or cannot do with bracketing of population due to the restrictions in the state constitution.
Yes,
Is that
sir.
correct?
We did the General Assembly did this exact thing for Dougherty County the last time too, because it dropped from 100 to 96.
Y'all got to put a plug in that.
There's that one other issue that if it is not, there could be some entanglement with some Supreme Court decisions on that, which would make it why it needs to be a general law.
And let me ask Ms. Travis, it's coming back from Legislative Council, as I understand. Wayne Allen looked at it. He is satisfied this is now permissible as a way of resolving the issue Ms. Fullerton brings to our committee. Is that correct? All right. With that said, we're going to open up to questions if we can, Ms. Fullerton. I have a question over here by Mr. McKillop.
I have a motion at the appropriate time, Mr. Chairman.
All right. Any members of the committee wish to ask questions of the presenter and sponsor, Ms. Fullerton? If not, does anyone else wish to speak to the bill? And you really want to speak to it? All right, so come on up. I want you to come up because we're being broadcast worldwide. sir.
Mr. Chairman and members of the committee, Mike Gucaro representing the Judicial Council and the Administrative Office of the Courts. Last week, the Policy Committee of the Judicial Council met to examine this bill, and by policy of the Judicial Council, since this changes jurisdiction and didn't come before the Judicial Council prior to it, they have a policy to oppose such bills. We understand that it would affect Dougherty County specifically, but it was the feeling of the committee that this change was unnecessary to affect what they wanted to do. So.
You're saying it's unnecessary to have the bracket changed, and therefore, if we don't change the bracket at the next election, could not someone seek to qualify as a probate judge candidate in Dougherty County who is not an attorney?
It is the understanding of the Policy Committee that once an Article 6 probate court, always an Article 6 probate court.
So the fact you're saying is, but is that worded in the act?
That was the understanding of the committee, yes, in the way it is written now.
It may have been.
Yes, let me finish. Where do you see that language, Mr. Caro, in the act? Because once you
Section
say
1,
the
yes.
1990 census brackets it, and there can't ever be a change, because what we say, or any further such census.
Once, it's the understanding of the committee that once you meet the qualification, according to any census, that county becomes a county with an Article 6 probate court, and that even if your population changes, once you have reached that classification, you don't slip back. That is their understanding of the wording.
Mr.
And
Chair.
I understand that there is I'm sorry.
Just a minute.
No, we understand that there's, I think, an appeal before the Supreme Court on that now. But again, I'm just transmitting what the feeling of the Policy Committee, which is made up mostly of presidents of the councils of the courts.
All right. Ms. Fulton, you wanted to say something?
Yes, sir. On the bottom paragraph on page 4 and page 5, I think it addresses
Your comments?
of my comments.
Okay, this is the case that you're speaking of.
Falling in and falling out.
Right. With all due respect to the Judicial Council,
Certainly.
I feel there's a need to put some belt and suspenders both on this one to be sure we don't have what we're talking about happen. And I'm encouraged to say that the bill, I would like to say all probate court judges be attorneys, but we realize that that's not going to be possible with a lot of your smaller counties. So I think it's reasonable to have the bracket ensure that with Dougherty and others of that size county would continue. Thank you.
Yes, sir. Thank you.
I'm ready for a motion.
Move to pass.
Motion is due pass. It's been seconded. Is there any discussion on the motion? Are there any amendments to the motion? There being no amendments, the chair will call the question. All in favor of due pass on LC 256046S as presented, signify by saying aye.
Aye.
Opposed, like sign. Motion carries. We have Mr. Meadows here on a important bill. I believe Mr. Meadows is in, and thank you, Ms. Fullerton.
you.
Appreciate your being here
We
today.
appreciate your kindness.
Ask Mr. Meadows, who needs to get back to other pending business. We're going to take up a substitute House Bill 1198, and the sponsor of the bill is Chairman John Meadows. Good morning, Mr. Meadows.
Thank you, Mr. Chairman, members of the committee. In my 8 years, this is my first trip to judiciary.
Welcome.
I don't even know how to spell that. I bring today House Bill 1198 that's been changed a little bit. I've had a lot of help from the chairman. This is a grandparents' bill, and I thought that before I even started, I'd tell you why I came. About 3 years ago, my aunt and uncle's son, his wife, killed him. Shot him 6 times while he was sleeping. They'd been very close to their two granddaughters, and after the everything went down, she walked, and she will not let them have anything to do with their grandparents. It's I think it's driving my aunt crazy. And so I thought I'd bring a bill, and again, it's highly unusual for me to be bringing bills from where I sit. This bill gives several factors for the court to use in determining if the health and welfare of a child would be harmed without contact. 4 of them, child resided with the grandparent for at least 6 months. The grandparent provided significant financial support, established a pattern of regular visits or child care. Other circumstances, the harm is likely. The parent's decision is given deference, but that it is not conclusive where harm would result to the child. The court may, and underline may, presume that if minimal contact is not allowed, it's harmful to the grandchild. The visitation is not to be less than 24 hours in a month unless the court decides. In cases where a parent's passed away, is incapacitated or incarcerated, the grandparent may have reasonable visitation. The custodial parent's judgment shall be given preference, but not conclusive. Whether or not visitation is granted, the court may, underline may, direct that the grandparent be notified by the parent of all publicly attended performances, recitals, athletic events, and things like that. And I'd be glad to try to answer any questions.
Thank you, Mr. Meadows. I think we do have questions. We have one from, I believe, Ms. Oliver.
Mr. Chairman, I've had this fact pattern in my practice also, where a parent dies and that the deceased grandparents are denied access. It's a real problem, and I'm going to vote for your bill. I know that people have told you that the Supreme Court has really danced around this issue several times, and we've declared a couple of statutes unconstitutional. The court has, but I think you may have walked a line here that'll the court will accept, and I'm going to vote for it.
Believe it or not, I've been told several times that the court has danced around. And again, when I brought the bill, the first thing that happened is the chairman said, hey, you know, I think I can help you with that thing. And he has. And the fact is, he helped so much that he had the only copy until I got in here this morning.
Well, you just didn't have the latest draft. We had it in our files.
Okay. Yes, again, the mays are in there, and I'm not trying to take anything away from any judge, but sometimes the right thing is put it down here whether they find it constitutional or not.
Well, I think Judge Lane may have a question for you.
Yes, sir.
I think that's Weldon.
Oh, Weldon's?
Judge Weldon, then.
I'm sorry.
I do support the bill.
Okay. Mr. Weldon, excuse me.
Mr. Chairman, I have a motion at appropriate time.
All right, we'll hold up that. And we have a question. Mr. Hatfield.
Thank you, Mr. Chairman. Chairman Meadows, I was curious on lines 44 to 45, the language that there shall be no presumption in favor of visitation by any grandparent is being stricken. Is it your intention to create a presumption in favor of grandparent visitation?
Well, I'd like to, but I don't think I am on that case.
So what is your understanding of the what would be the result of striking that language?
Again, I want to make sure that the judges have all the leeway they possibly can. Sometimes I don't know, or anybody else knows what the situation is before we start, and I don't want to presume that they have a legal right. One part of this thing is if the parents are living together, married, there is no thing. I just trying to get something to where we might help some people.
I think, just to follow up with Mr. Hatfield's inquiry, the purpose of that is it's contrary to what has been the rulings of the court on the issue, that there cannot be a presumption one way or the other. Over here we have, yes, sir.
And just in following up on that, I think that if you put a presumption in there, it would then it would actually conflict with the language on line 53 where it says that a parent's decision shall be given deference.
Yeah. And that's what the courts have generally ruled, is the state is not going to generally interfere with parents, joint parents' decisions on questions of grandparents' visitation. Any further questions of the presenter? If not, Mr. Meadows, I appreciate your taking the time to come be before us.
Thank y'all for having me, and
don't be a stranger.
I'm not coming back.
Well, we might do well if you just stand by for a minute.
If I do come back, y'all remember it.
All right. Hope I'm still here. Anyone else wish to speak on House Bill 1198? If not, we will close all further public comment. The bill is now in the rest of the committee. Do we have any discussion among committee members? There being no discussion, the chair will entertain a motion. Second. It's been moved, do pass, and seconded. House Bill 1198. Is there any amendments to that motion? There being no amendments, the chair will call the main question. That question is a do pass to House Bill 1198, which is LC 29-5226S, as presented in committee. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Thank you, too. Mr. You can count on it. Might be on the day, you know. Okay, we're going to take up HB 748. Is Mr. Brockway here? Yes, sir. Come around and let me have you present that bill for us. That is House Bill 748 by designation.
Thank you, Mr. Chairman. Members of the committee, I think need to mash the button. Thank you. Bring it back to you, House Bill 748. I think looking around the room, I see most of you were either here during subcommittee or during the full committee when I had this bill here before. And basically it deals with the ability of adult adoptees to obtain a certified copy of their original birth certificate. We've added an amendment to it, which you see beginning on line on page 3, line 62. Basically what this amendment does is provide an option for parents, mothers and fathers who are giving their child up for adoption, provides a method for them to express their wishes in the form of a piece of paper that would say, I want to be contacted, I don't want to be contacted. We call it the contact preference form. It allows that form will sit on file. A list will be created by the state registrar, and when a request comes in, a request comes in for a copy of an original birth certificate by an adult adoptee, it will be checked against that list, and a copy of that form will be provided along with a copy of the original birth certificate. This is a method that's been used in a number of other states, and we hope that this is a good way to address some of the concerns that folks had about violating the privacy of birth parents. That's basically what it does, and Mr. Chairman, I'll be happy to answer any questions about it as best I can.
So other than that change, the bill as we passed this committee previously remains the same?
Yes, sir.
That's the only change we've made?
Yes, sir.
All right. Any questions by members of the committee of the presenter? Yes, sir. Mr. Rogers.
How would this work if the child is born in a state other than Georgia?
Well, this only, birth certificates, it would only be for people who were born here in Georgia. So if someone is born, an adoptee is born here in Georgia, then we have their original birth certificate. If it's in another state, then they'd have to go to that other state and follow the laws of that state.
Okay.
Thanks, sir.
Other questions of the presenter? Yes, sir. Just a moment. You have a question,
Yes, sir. Just
Mr. Lindsay?
briefly. And I guess I sort of soul-searching question for you at this point. You had a fairly simple bill with a fairly simple rules before. Now you've got a lot more administrative aspects to it. The question for you now is simply this. Would you prefer to wait a year and try to allay the concerns of folks about your original bill, or do you think it's better for us to move forward?
I think it's better to move forward. I think we've got a method that's been used successfully in other states to deal with those concerns that people have. So I'd like to move forward.
All right, with that, Speaker, Mr. Chairman, at the appropriate time.
Yes, sir. Any members of the committee have further questions of the presenter? All right. Do we have anyone else who would like to address the committee and the audience? Yes, sir. Come around. Give us your name, please, sir, and your interest.
Good morning, Mr. Chairman and committee members. I'm John Collar. I'm a lawyer, and I'm also the legislative liaison for the Family Law Section. And I really just want to ask a question about, just to get clarification about the contact preference form. Does this legislation mean that if the biological parents who put the child up for adoption elect for their identity not to be disclosed to the adult adoptee, does that assuage those concerns?
Those concerns will be made known to the adoptee. I think we're kind of getting into a situation. What's the difference between privacy and anonymity? Birth parents always have the right to privacy. They always have a right to not pick up the phone, to say no, thank you. But this makes that preference known.
So if I'm giving up a child for adoption and I don't want the child to know my identity, that will remain confidential.
That preference will be made known to the adult adoptee 18 years later when that person becomes an adult, if they choose to seek a certified copy of their original birth certificate. That preference will be made known.
Well, okay, thank you for that clarification. The only concern that has been expressed to me by the varying committee members of the Family Law Section is the fact that we do run into situations where a parent who's giving up a child for adoption doesn't want to ever have their identity disclosed by virtue of the process, and part and parcel it sometimes is a fairly significant aspect of the decision they make as they go through the adoption process. So that would be the only concern that I would relate to the committee from.
And Mr. Chairman, I've got a letter here from the Georgia Council of Adoption Lawyers. Right. These are the folks that do this every day, and they're in support of this bill.
We understand. Yeah.
And I'll be happy to provide a
we
copy
had
of that
we had
for
a
everybody
lengthy
on the committee.
debate. That I agree with you. It's been a matter of concern for years with this committee as receiving bills on adoption as to the disclosure rights that a child may have at future times, and so we're trying to address that, recognizing there's also the other side. The parent has made a decision, and whether or not that decision holds true 18, 19, 25 years later remains to be seen. But the question is, if there was a contact, as we say, the person say, I don't want to talk to you, and hang up the phone.
I understand. I just want to make sure the committee was aware of, of our concerns.
Thank you. Much aware of that. We have a question, I believe, over here, Mr. Powers.
Currently, as I understand it, if an adult wants to find out some information about his or her birth parents, there is a reunification program that's available. Why, rather than creating all of this, if there has been a reunification sought and the parties have, in fact, made contact with each other, why wouldn't it be just as simple just to, if I am the adopted child, when I made my request for the birth certificate, I just have a sign, since I have been reunified with my original parents, why would I not just have a signed statement saying that they had no objection or they gave their consent, rather than creating this additional bureaucratic paperwork where things may get lost and they may not be in the right file or whatever?
Well, I think you're right. Georgia has a reunion registry that's been around since about 1990, as I recall. And that works fine for the folks that choose to participate in it. I think the problems that we're seeing is about half of all adoptions are really just step-parent, step-child situations where already there's no need for reunification, and probably 95% of those cases they're already known. So I think that half of these are already in that situation. I just think that first of all, I don't think this creates a whole lot of paperwork. We have about 4,000 adoptions in Georgia a year. About half of those are stepchild, step-parent situations. We're not going to create a whole lot of paperwork. We're just asking them giving the parents the option to file a piece of the parents who are giving up their child for adoption, the option to fill out a piece of paper and say, here's my preference. They don't have to fill out that preference if they don't want to. If they don't want to express their preference at all, they can leave that the way it is.
I think, let me follow up. I think, Mr. Powell, also the reunification program is a voluntary one that people have to know about and voluntarily contact that organization to register their name one way or the other, and they may not know about it. Point being, this is another alternative to that if there's to be a recognition of the parent, mother of this child 18 plus years later.
Well, I guess my point is that as I understand it, if I'm an adopted child, I contact the reunification registry and say, I want to contact my birth parents. Then they make an effort, as I understand, to contact those folks and see if they want me to make contact. And if they say no, then it seems to me to be contradictory that they've said no, and yet, they can still be found another way by release of the birth certificate.
I think you're confusing two issues. This is just an attempt, and this is not about reunification. This is about an attempt by folks to obtain their own information. They can, there are people who don't have a copy of their original birth certificate who still find their birth parents through other means. So this still continues to happen. But
if a parent says, I do not want contact, and yet somebody comes and gets the birth certificate, then that gives them the ability to find that parent when the parent does not want to be found. And that's contradictory.
Yeah, I understand what you're saying. But I think, I just think folks have a right to their information. And I think this, we provided a method where people's opinions and their preference can be made known.
Mr. Hatfield. Wait. Stop. We don't take comments on that basis. We have people who are recognized to speak and then ask questions. Mr. Hatfield.
Thank you, Mr. Chairman. Representative Brockway, I was looking at the language on lines beginning at the end of line 53 and going through 55 on page 2. A copy of the original birth certificate shall be in a form that clearly indicates it is not a certified copy and that it may not be used for legal purposes.
Right.
Why is that language in there?
Well, because when you've been adopted, it's stamped or written on the original birth certificate that has been canceled by adoption. So it's not a legal document. Their legal document is their adopted birth certificate. So this can't be used for any legal purpose.
Well, it's your intention then that it be not be able to be used for any purpose at all?
No legal purpose.
Well, what purpose would you use it for?
For information, and there are other things. Sometimes, in the wake of 9/11, the State Department has cracked down on the issuing of passports, for example. There are cases where an adopted birth certificate may be missing inadvertently, or just information left off, a key piece of information that's necessary for the State Department to issue a passport. In that situation, while it may not be a legal document, it can provide a valuable piece of information that's necessary to obtain a passport. So there are other purposes,
Okay.
just not legal ones in the sense that I can go get whatever legal purpose may arise.
I can't.
Inheritance, etc.
I can't right off the top of my head think of any purpose necessarily that you might seek to use it for, but I feel like there may be some things that a person might want to use it for if they got their hands on it.
Yeah, and that may be the case, right? But I think that's why hopefully the original adopted birth certificate, that being the legal document, covers any of those cases that may arise.
Okay.
All right. Any other questions of the presenter? If not, we appreciate it, Mr. Brockway. Do we have anyone else in the audience who would like to speak to the bill before we cut off public input? If not, the chair will cut off further comments from the audience, and the bill is now in the breast of the committee. And we have Ms. Oliver.
I'd like to make a motion at the appropriate time, Mr. Chairman.
Thank you. Any discussion among committee regarding the bill? If not, the chair will entertain a motion.
Move to pass.
There's been a motion do pass. Is it seconded?
Second.
It's been seconded. Any discussion on the motion? Any amendments to the motion? There being no amendments, the chair will call for the main question, which is a do pass of LC 334687S as presented to the committee. All in favor signify by saying aye.
Aye.
Opposed, like sign. Chair rules the motion carries on the voice vote. Next we have, I'm going to take Mr. Carson. Your bill is going to be next, 1089, since you're sitting there and like you're ready to go. Thank you. We're here on House Bill 1089 by Representative Carson.
Thank you, Mr. Chairman. Committee, I'd like to present to you House Bill 1089. This is just a one-page bill. Essentially what we're doing is repealing a section, a chapter of the code, Chapter 67 of Title 36 that has to do with zoning proposal review procedures. Basically what was put in, a little bit of the history here. There was some Steinberg criteria that was put in 1985 that based on the population affected only Fulton County at that time. And it required additional zoning review criteria for parts of, particularly for parts of unincorporated Fulton. Over the past 25 years, the population number was not increased appropriately in 1990, and therefore it pulled into DeKalb and was never intended to do so. And these numbers were updated in 2000 as well. My intention here, the people that brought this to me was my home county of Cobb County. They are concerned about some items here in Section 3 of the chapter that we're repealing in regard to review standards. That they're concerned that there might be more financial feasibility studies that are unnecessary, and they would like to not be encumbered by this, as they already have their own zoning standards and so forth. I have spoken with members, representatives from Fulton and DeKalb counties, specifically Fulton. I've got confirmation that this would be fine to repeal, that they do these standards anyways. Actually, the same thing with Gwinnett. I would also say if we don't update these, at least update these numbers, I would prefer to repeal this chapter. That based on the 2010 census, Mr. Chairman, this is not only going to affect Fulton and DeKalb, but also pull in Cobb and Gwinnett.
I think that's the concern. We're now spreading out with the county's growth, these limited needs, and I believe your push, is that right, Ms. Oliver? Chair has Ms. Oliver.
I had some discussion about this with Mr. Jacobson, and I thought there was a possibility to allow it to repeal it only for Cobb, but still allow it for DeKalb. The Steinberg Act came out of DeKalb County politics. My history,
From
remember.
Kathy Steinberg, yes.
And so there was an interest in, from my perspective, in whatever protections it provides, that it still remain valid law for DeKalb, and I thought that was a substitute we were going to be bringing forward. I haven't followed up since we had that discussion, so that'd be my preference rather than a total repeal. And I know the population acts are getting a lot of attention right now.
You want to be recognized? Yes, sir.
It's my understanding that this is, Representative Steinberg was from DeKalb County, so this actually was intended to apply to Fulton and DeKalb when it was.
I must have misunderstood that from Legislative Council then.
When it was adopted. In discussing that issue, Representative Oliver with the chairman, the chairman expressed a preference that we instead allow local governments to address this this matter by themselves. As I understood the issue when Representative Carson brought it to me, you had a letter from Legislative Council that basically made clear that under local government's home rule powers, they can adopt these same procedures rather than having them mandated from the state down. So.
The purpose of the Steinberg Act was to walk a line granting local home rule to counties, but having some rational standards.
Why don't we get to a discussion, which we'll have in a minute with the committee on the point. I want to be sure we finish with questions of the presenter, and then anyone else wants to address the bill at this moment. Ms. Oliver. Anyone else wish to ask questions of the presenter, Representative Carson? If not, we appreciate your being with us today. Anyone in the audience wish to address the bill? If not, we will close all further public input. The Bill 1089 is now on the breast of the committee, and I believe, Ms. Oliver, you had reason for discussion. Please.
I believe the Steinberg Act specifically was declared constitutional. Am I remembering that correctly?
I think if you were asked of the presenter.
My understanding from dealing with Legislative Council as well as I was receiving some information and advice from the chairman of Intragovernmental Coordination is that these population acts by and large are unconstitutional, and it can only be changed, as per the Legislative Council letter from Jeff Lanier, can only be changed in two ways. Either one, to change the population brackets to only include those counties that were affected in the prior census, or to repeal it.
But I think my question related to the Steinberg Act in and of itself, to the extent it made some standards in addressing the zoning acts in terms of a home rule issue, was declared constitutional.
I don't recall, but I think we can take the presumption that it was declared.
Yes,
I think what we're saying is procedures can be addressed by the state through legislation, general legislation. What we have here is a general legislation of a population bracket, which now is bringing in other counties because of growth. The question is, do we want to continue it as a population bracket bill, or do we want to set up general legislation that will be applicable to all counties for zoning, which we do. We have provisions that apply to everywhere,
yes, sir.
Cities and counties. Now, do we have something specialized as another form, which was adopted back when we had population brackets as a way of doing general legislation, which has been since prohibited by the Constitution?
Mr. Chairman, I had no interest in interfering with Cobb County zoning, but I did, to the extent I looked at this earlier, did want to protect the Steinberg Act protections for DeKalb County. So the fact that we're not able to do that this morning, or that hadn't been the preference of the drafting, I just feel loyal to my county that's been using this effectively for a good while, I think.
We can address that by motion when appropriate time. Another question over here.
Thank you, Mr. Chair. You answered the question. We'll address it in a motion from DeKalb County.
Thank you. Any other comments, discussion among the committee members? If not, the chair will entertain a motion at this time. Any motions? You have a motion do pass. Is there a second?
Second.
It's been seconded. All right. We have a substitute motion. What would that motion be? Chair recognizes Ms. Oliver for substitute motion.
I move that we table 1089 for the opportunity to address the population issue as a way to protect these Steinberg Act for DeKalb County.
All right, we have a second. Is there a second? All right, we do have a second. A motion to table takes precedent. There is no discussion on the motion. All right, what's your question?
To the authors of the amendment, do we have language that y'all could put together in the next hour that would allow? I have a problem with tabling it if we can fix it now by the end of this meeting, but I don't want to thwart the author of this bill's need to fix his problem over in Cobb County.
May I inquire with Ms. Travis about what it would take to?
Well, I think we get back to the question of. Well, I think we got. Before you inquire, let me ask Vice Chair. You got a comment?
Yeah, I mean, I've given that some thought. The problem is that with this particular group of counties now, you've got Fulton County with the most population. Gwinnett has now come in ahead of DeKalb, and then you've got DeKalb County, and then you've got Cobb. So if any band that is intended to take in both Fulton and DeKalb is necessarily going to take in Gwinnett. And so the only other way to do this, which I'm hesitant to do, is to tie it to the MARTA penny sales tax. Well, and of course, if you do that, you're putting more. Well, and that was. I mean, again, Representative Bruce, this was thinking through. The only other way to handle this, and frankly, I am hesitant to tie down to bog down the MARTA penny and other jurisdictions maybe one day participating in it with additional restrictions.
Okay, if DeKalb County legislators want it to be tied down, for now, but I do think that the Cobb County folks have a real problem here. I'm going to recommend that the bill go forward. I'm going to vote for the bill to go forward, but with the understanding that if we get to rules that I assume to be modified structured, if by then you can have an amendment that simply ties down DeKalb County, I'll be happy to sign that amendment, and I'll be happy to help move forward in rules so it could go to the floor just to tie down DeKalb County. But for right now, I think in order to help folks in Cobb County who never intended to be part of this, I think it's important for us to move forward to help the Cobb County folks, but that's my pledge to you.
Are we back in discussion? Anything else as far as discussion? The motion, please. There's a motion to table, been seconded. That takes priority. The chair will call for the question to table. All in favor signify by saying aye.
Aye.
Opposed, like sign. Chair rules the motion fails. We're back to the main motion, which is the motion do pass. That was seconded. Any further discussion on that motion? Any amendments? If not, the chair will call the main question, which is the motion do pass on House Bill 1089. All in favor signify by saying aye. Opposed?
No.
Chair is in doubt. The chair will call for hands. All those in support of the motion do pass signify by raising your right hand. We have 1, 2, 3, 4, 5. All those opposed, we have 1, 2, 3, 4, 5. And the chair votes to pass. There'll be a 6-5 vote on do pass.
Thank you, Mr. Chairman.
Thank you. The chair is not going to call House Bill 960 at the request of the author. And next we have is House Bill 1132, the Fair Business Practice Act. Mr. Dickey. Well, let me say this while we're having Mr. Dickey come forward. We have Judge Boyette. If you would please recognize, Judge, we're glad to see you again. Always a pleasure to have you from the Cotasauga Circuit, Murray, and Whitfield counties. Pleased to have you, sir. Mr. Dickey.
Thank you, Mr. Chairman, and members of the committee. Like it's consideration day of House Bill 1132, the Fair Business Practices Act, relating to telemarketing practices. I know everyone in this room, like myself, who's a business owner, or runs a business received unwanted solicitation calls in their business or repeatedly received these calls in spite of the no call registry. These calls occur every day, soliciting many types of products and services, and override our call ID system, use false names. They're unwanted and they're very costly for businesses especially. This bill has 5 points I want to bring to your attention. At the beginning of a call, we're asking the person or entity to clearly state their identity. Persons or businesses. Number 2, persons or businesses making these solicitation calls cannot purposely block their phone number or circumvent the use of call ID service. 3, the telephone number displayed has to be a real working number capable of receiving incoming calls. And 4th, the identity of the caller displayed will be the actual identity of the caller. Put a pretty tough consequence in here. Violation of this code could bring a class action suit. Current law does not provide meaningful remedy, and that's why I've asked for class action status. If you're going to stop it, you're going to stop it. I just wanted to ensure that all businesses conducted in the state via telephone, is an upfront, direct, honest manner like any other person would want to do. And so that's just kind of a code of conduct that I thought that ought to be done since we have so many automatic dial telephone services and other things that I just thought this made sense. Have not had anyone contacted me opposing this bill. Checked with some telecommunications company, and they, at this point, to my knowledge, have not seen any concern with it. And I have one person wants to speak for this thing, too.
All right. We might refer to this as the Lawyers Full Employment Act of 2012. Mr. Maddox. Oh, no, I'm sorry. I never can tell between the phones here. Mr. Hatfield.
Thank you, Mr. Chairman. A couple of questions, Representative. What about calls such as political calls?
This would cover robocalls too.
It would,
but the company would have to. I do political calls as probably well as you do. First thing I do is state up front, who's it from, and it just needs to be from a working number. Many of these other automated calls, block the number they're from. So I have not heard of an issue where these automated calls would,
I think a lot of those calls come from numbers that you can't call back, but I'm not sure about that. That's a concern to me because I think you potentially are putting limits on free speech rights. But although I understand the intent of the bill and have some of the same problems you're describing, I get frustrated and upset with some of the calls that you get. But I don't want to do something that's going to capture activity that we feel like should not necessarily be regulated in that way. The other question I had was on page 2, lines 50 through 53. Is it your intention that there would be a right to bring an individual action or only a class action?
I would like to see both.
Okay, Ms. Travis, would this provide for an individual? Okay.
Under 10-1-399. So there's a remedy, but I believe it's through the administrator as opposed to an individual action. And Representative Bigby's desire was to have an alternative.
Okay, so it's either through the administrator or a class action, or if this bill passes. Okay.
All right. Ms. Evans?
Thank you, Mr. Chair. To address Mr. Hatfield's concern, the way I read the definition of telephone solicitation starting at line 29, which is used in the language of subsection B starting at line 37, telephone solicitation actually being at line 39, to what actually comes under this bill. It talks about, to be a telephone solicitation, you have to be encouraging the purchase or rental of or investment in property, goods, or services, or a donation. So as long as you weren't seeking a donation, if you were just seeking a vote, do you think, I think that language means that our regular campaign robocalls would be protected. Do you agree with me?
I would hope so. I really didn't intend to block campaign calls, and that's a good point.
I don't think we can. Frank,
right.
They do stand as First
Good
Amendment rights.
Yeah,
so
I've certainly
legislation would
go
do
along with that. Representative Hatfield as well. I mean, so I didn't intend that.
Thank you, sir. Any other questions of the presenter? If not, you mentioned there was someone else who would like to speak. Let me get my sheet up
Mr.
here.
Brink Dickerson wants to briefly.
Hold on, I'll call on somebody as soon as I find my call sheet. Oops, there we go, Yellow. Thank you.
Thank you, Mr. Chairman. I'm Brinkley Dickerson. I'm a partner with Troutman Sanders. We have 551 employees and attorneys in Atlanta. We get tens of thousands of robocalls a year. We easily estimate the cost to our business at over $10,000 a year. Now, we can't block these calls because the numbers are always changing, the names are always changing. Often it's somebody who calls as a wireless call, so you think there's some sense of urgency, and so you answer it. Other times it's a legitimate business name, but that's not what they're calling about. They want to sell you Google ads, they want to sell you insurance, they want to sell you credit improvement plans, they want to sell you debt consolidation. And it's just a ridiculous expense for Georgia businesses to have that kind of interruption when they don't want it. We did craft the bill with the representative's assistance to address sales of goods and services, so I don't think it will cover anything political in nature. That certainly wasn't the intent in the drafting. We crafted it so it dovetails with existing legislation, which governs only security sellers, commodity sellers, and home improvement companies, so this broadens it out. We thought carefully about our former governor's litigation about spam faxes last year, or the year before, or lawsuit. And we tried to craft it so that individuals who were just tired of the harassment could do something that would discourage it. And that's why we put remedies in that are a little stronger than a lot of people wish they would have to be. Would rather not burden the state. Let's just let private enterprise, the full employment of good lawyers if necessary, let's let them go after the bad guys. No honest business doesn't have pride in their name and pride in their phone number and want to put it on their caller ID. The only people we're dealing with are bad people and bad businesses, and I don't think any of you has a single constituency that wants robocalls from those people.
Thank you, Ms. Dickerson. We have questions of you. First of all, we have Ms.
Yes,
Lindsay.
Just from Representative Hatfield raised an interesting point in that a lot of these robocalls, I'm not sure if you can, while the phone number does pop up, I've never tried to call that number back, but I'm not so sure if they're capable of taking an incoming call.
The robocalls from companies such as the big one here in town that Mary Norwood owns do have a return number that you could call and somebody would in due course answer. The robocalls that we're trying to stop never do. You know, a very common one right now is somebody who's trying to sell you give you a 30-day free health insurance program, concierge health care, and it's a 201 phone number. And if you can dial it forever and you're going to get a discontinued message. So the good providers do have a main number that is a valid return phone number. The ones that don't want you to have that ability to call them back, block it.
All right. Yes, sir. Vice Chair.
I guess I actually have two questions. I'm looking at subsection C, the right of action provision, and I note that the Fair Business Practices Act actually has an individual private right of action in it. So is it the intent here that in addition to, and the way this is written is cumulative, so it's the intent to have the ability to have the administrator pursue these, to have a class action, or to have any number of individuals suing on this?
The goal is to make it expensive enough for the people that do this so that it'll discourage them. And nobody nobody wants these calls. And if I sue for my personal damages and I have to go prove it, I'm going to have to say, well, it took me 25 seconds and my time's worth, whatever it is for 25 seconds, and that's all I'm going to be able to recover. So we had to create some sort of a structure that would let me, if I'm the annoyed person, sue ABC company from Montana who's doing these calls with enough impact that they would stop and not do it anymore. And remember,
Right, so
we're not telling people they can't call. We're solely telling people you got to use your name, you got to give people a phone number.
all right, and then the second question is this. I mean, I haven't thought through what the implications of allowing everybody who receives a call to sue individually for a violation of the Fair Business Practices Act might be. So there's that issue, and then the other question is this: when you say receiving incoming calls on line 46, I mean, is that just? I mean, that's not defined. So is that simply having a working phone number, or is it sufficient to have a? I mean, is it sufficient to have a working phone number that has voicemail attached to it, or?
That would be fine.
Well, except that's not. I mean, I guess my point is,
Once you have a working
that's not defined.
Any phone number that's valid works, because at that point you can block it on a phone switch. At that point you can complain about the calls to an appropriate person. But if you don't have a phone number and a name, there's nothing you can do under any scenario.
I mean, and on that, I may just be splitting hairs. I mean, it just seems that you might want to have that more specifically defined.
Thank you. Mr. McKillop?
Thank you, Mr. Chairman. My question has to do with the definitions. At line 14, under AD equipment, it defines it as a pre-recorded message, and it seems to only limit it to robocalls, pre-recorded messages. The only place that AD equipment is used in the bill is at line 30, and under the other definition of telephone solicitation, which says from a live operator. And maybe I don't understand exactly how these work, but it seems to me that if we're looking, this means any voice communication from a live operator, but then it says through the use of AD equipment, which only includes recorded calls. Can you explain?
I think that's a good catch. This was edited a bit by the legislative department, and I think that slipped in there and would suggest...
No, what? Operator. Or by other means. Thank you. Thank you.
All right. Any further questions of the presenter? If not, we will appreciate you being with us today, Mr. Dixon. Anyone else wish to speak on House Bill 1132? If not, the chair will call further public comment. The bill is now in the breast of the committee. Do we have any discussion among committee members? If there's no discussion, the chair will entertain a motion, excuse me. Is there a motion?
Move due pass.
Motion is due pass. Is there a second?
Second.
It's been seconded. Any discussion on the motion? Do we have any amendments? Mr. Hatfield.
Yes, sir, Mr. Chairman. At the end of line 36, remove the period at the end of the line, add a semicolon and the word or, and then add a subsection C, which would read, communication, which convey a political message. So it would read subsection C, which convey a political message.
And you also want to strike the or on end of line 34.
Yes, sir. That's correct. I forgot that one.
Is that right, Ms. Travis? All right, so we have the amendment. Why don't you state your amendment one more time before I ask for a second?
Okay. Then at the end of line 34, strike the or. At the end of line 36, strike the period, add a semicolon and the word or, and then add a subsection C with the words which convey a political message, period.
Do we have a second to the Hatfield amendment? Second. It's been seconded. Any discussion on the amendment? Ms. Evans.
Thank you. I have concerns about adding this subsection because I think the exception could swallow the rule, and if I was trying to sell you health insurance at the end, I could say, and vote Mitt Romney for president, and then I'm protected. So I think since we've already looked at the definition of telephone solicitation, plus I think generally political speech is not considered solicitation, so I think we're otherwise protected, and I think this may potentially gut the whole purpose of the bill.
All right. Ms. Oliver?
That's essentially my comment. I don't see how you could define political message either in a way that would be helpful without gutting the bill. So I agree with Ms. Evans. Right. Welcome back, by the way.
Any further discussion with the Hatfield amendment? The chair will call for the question on the amendment. All in favor signify by saying aye. Aye. Opposed, like sign.
No.
Chair is in doubt. We'll have a show of hands on the Hatfield amendment. All in favor of the amendment signify by raising your right hand. We have 6. All those opposed, like sign, right hand. 1, 2, 3, 4, 5. The amendment passes 6-5. Any further amendments? There be no further amendments. The chair will call the main question, which is the due pass of House Bill 1132 as amended as a committee substitute. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Thank you, sir.
Mr. Chairman, Chairman, it is required. I came in a little bit late. Should Representative Evans be allowed to speak without showing name?
We'll have them put up on the screen in the House today. We're going to call on Mr. Maddox, House Bill 665, Clerk of the Superior Court Bill. I know you've been working on this a good while. We'll let you take the necessary time to walk us through it.
Thank you, Mr. Chairman, members of the committee. I bring to you a substitute to House Bill 665, and I'd like to start by saying that this bill has been vetted to this point a great deal, and I'd like to list what we started with. The groups of interest around this bill dealt with every level of judge, from probate up to superior court clerks, of course, the administrative office of the courts, the council of superior court judges, GMA, ACCG, Sheriff's Association, the land surveyors and engineers of Georgia, the press association, Secretary of State, archives,
wow,
and the trial lawyers. And we have, to this point, been through 4 subcommittee meetings. As you can imagine, with the groups that I've mentioned, with great interest in the bill, and has been changed and been compromised all the way around. As you can see, it is a lengthy bill, and basically what it is a clarification, a revision bill to the code sections that affect the superior court clerks. In a large part, it makes references to being able to accept more information and record more information in a digital format, which they have been doing for some time now through their clerk's authority. And I'll try to take you through the bill.
We're dealing with LC 29519 ERS.
ERS, that is correct.
Go ahead.
And what we've got is, for example, Section 1.1 deals with depositions, changes the standard that they can be recorded in digital format and destroyed thereafter, and can be archived in digital format. Section 1.2 deals with the general execution docket, making reference that it could be kept in paper or electronic database form. Section 1.3 clarifies the eligibility of a clerk of the superior court to be a clerk for other lower courts. Section 1.4 relates to the changing of appointment of a clerk by a presiding judge, and what we're changing there is that the chief deputy, if one is appointed, would fill that position.
The past has been appointed by the probate judge, I believe, has it not?
Correct. And it would still be if there was not a chief deputy clerk, and if there was less than 6 months, chief deputy or whoever if in the event there wasn't one, whoever the probate judge appointed would serve out the term. If more than 6 months, there would be a special election. Section 1.5 was another code section dealing with appointment in the event of a vacancy. We are striking that section because we have expanded the previous section to involve that. Section 1.6, there's some cleanup language in that section relates to an emergency appointment in the event like a clerk was in a car accident or something. Then cleans up the language there in appointing someone to fill in the event of an emergency. Section 1.7 is stricken because we've expanded Section 1.6 to incorporate that language, trying to tighten up the code section and include and condense any way we could. Section 1.8 is just updating. You can see just a little wordsmithing there to clean up the language in the oath of office. Section 1.9 was of great importance to the ACCG in particular. What we're doing there, statutory bond is $25,000 for Superior Court clerk. Everybody agreed that needed to be updated. The agreed upon figure was $150,000.
That's the expense of the county too. That's why it was, I guess, an issue with them.
That's correct. That's correct. Section 110, some general wordsmithing there. No substantive change. Section 111, dealing with the duties of the Superior Court. Additionally, you'll see at the bottom of page 11 there in Section 111 that the clerk shall record, microfilm, or digitally image. Again, as I stated in my opening comments, that a lot of this is referencing the ability of the clerk to be able to do these recordings in digital format. However, on the next page, page 12, starting on line 396, we are eliminating. There's a provision there with respect to holding clerks in contempt. We are striking that specific language because elsewhere in the bill, specifically Section 119, we're changing such that the clerks will be subject to the general contempt powers of the courts.
All right.
112 again refers to the grantee and grantor-grantee indexes that the clerk can have an electronic computer-based database for review of such records. 13, Section 113 on page 13. Generally, you'll see for the next few pages there's a lot of language that's being stricken with regard to plats and maps. And basically, what we're doing is on line 428 of page 13, is saying that the maps and plats filed with the clerk are now going to have to be subject to minimum standards and specifications adopted in the rules and regulations of the State Board of Registration for Professional Land Engineers and Surveyors, which I think is they take their the minimum standards now. That's the kind of the custom now, so we're just codifying that. Again, Section 114 deals with the display of maps to provide for that images of plats and maps submitted to the clerk on or after July 1st, 2012 can be they can provide access to those in electronic format and have to provide necessary equipment for printing off of those maps and plats should someone in the public desire that. Section 115, we're changing retention schedule determined by the Superior Court has been changed to, it used to be when records were over 15 years of age, it's been reduced to 5.
Why is that?
I don't know. I can call Mike Holloman up from the Clerks Association. It's my understanding that that's been a court rule change.
Okay. I guess what the question there, I'm not saying it's right or wrong, just there are times where I've had to go back many years looking at a record, and if it's on microfiche, it's tough sometimes trying to read that.
And I will state that this is dealing with instruments that conveying personal property
Is it?
only.
Okay.
Yes, sir. That's not the retention schedule for.
It talks about paragraph B, civil pleadings. I'm reading there. Which I'm curious as to what the format will be. We'll ask Mr. Holloman when he gets up here.
Yeah, and if you'd like, maybe he can come sit with me now if there's any specific.
Not a problem. Come on up, Mr. Holloman.
Along the way, we
May
can
get some
address it
things
as
later.
we go.
We were asking about the
yes, sir.
Purpose of the change, especially as to civil pleadings.
The truth is, in paragraph A, is Representative Maddox has noted, it's referring to personal property only. On the paragraph B relating to civil pleadings, I've just asked 2 of the clerks in the room. They keep all of those records in the minutes of the court, so they're already available in that form.
Full pleadings? I think you
gonna
just
have to
have
ask.
I think the minutes only reflect what was action taken by court, and I'm concerned about there being something more than just that. Just
okay.
Recognizing there's always a. I'm saying I know in my own practice, going back over the years, I've had to go back and pull up pleadings, going back a number of years to look at it, and I know they get microfished after a period of time. And I just say I've had to try to read those things.
Yes, sir.
And you can't, frankly, get a
I
legible copy of it.
Yes, sir. Mr. Chairman, my recollection or my understanding of this section was dealing with personal property in paragraph A. If the committee would like to go back to 20 years on the civil pleadings, I don't understand the full impact of that, and I'd be comfortable with that.
We'll keep that in mind.
We're principally interested in paragraph A.
Okay. You want to wait, Mr. Hatfield? We'll get.
Yes, sir.
Are you going to go ahead and ask about something now?
I was just going to make a statement.
Follow up on what you said, that that concerns me, particularly in domestic relations cases. You might have a modification or something that would come up 5 years, 7 years after an original action, and you need to be able to go back and find all those pleadings.
Yeah. We'll keep that in mind as we get to the later bill. Yes, sir.
If I could point out, those are accepted in the last sentence of paragraph B.
Mm-hmm. Well, it involves divorce, but maybe not a modification issue. That's questionable there. But we'll handle it at an appropriate moment.
That'll be
yes,
fine.
Sir. Go ahead, Mr. Maddox.
Section 116 deals with legal organs and basically adds in the ability for them to convey the legal ads that the Superior Courts are required to keep in digital format. Mm-hmm. And that was with the agreement of the Press Association.
All right.
Section 118 reword is some wordsmithing involving payment of transcript cost. Essentially, nothing is changed there. It's just reworded in a different manner.
All right.
Section 119 is what I referred to earlier with regard to how a Superior Court clerk could be punished by a judge, and we're changing it to simply say subject to the court's power of contempt as set forth in Code Section 15.14 and 15.68. And 15.14 talks about the contempt powers of the several courts, of all the courts, and 15.68 is specific with respect to the contempt power of Superior Courts.
All right.
Section 120 deals with changing the process by which a Superior Court clerk is removed. But as you can see, the current language is approximately 4 sentences, which just says that Superior Court clerk subject to be removed by the judge of the court for any sufficient cause, and the charges must be exhibited to court in writing, facts tried by the jury. Felt like that language was a little bit broad. The sheriffs have a process of investigation and removal that we felt like would be appropriate in the case of Superior Court clerks. So it would change it to the governor determining that a clerk needs to be investigated, and that could be initiated by a member of the public, a judge, or anybody. And the governor determines the investigation needs to be started, then a panel consisting of 2 Superior Court clerks and someone from the Attorney General's office makes up the committee. They do the investigation. They can recommend suspension, which the governor can do, and ultimately, in the event of that the governor feels like the clerk needs to be removed, or the committee has submitted evidence that suggests such, then the governor can recommend that the DA in that county initiate a removal petition, which has to be tried in the court there.
I think this is where you had some discussion and attempts to negotiate. Let me ask a couple of questions if I can by this point. Are all clerks, Mr. Holloman, members of the Superior Court Clerks Council?
Yes, sir.
So
By
we
law.
don't, by law they are. So we just say 2 clerks of Superior Court. Doesn't need to have, say, who are members. I guess the question was, are we making a limitation there in any way? The other thing is, it says the committee shall make a report of its investigation within 30 days, and it says from the appointment of both clerk members, as opposed to saying just appointment of the full appointment of the committee. Is that a reason?
Not to my knowledge.
Okay. And lastly, I see there's apparently a need to have a further, if there's a further investigation, which I don't know what that would mean, the governor can order additional investigation by either the committee, the Georgia Bureau of the law enforcement agencies, or even now a special committee appointed. What are we doing there?
And to be clear, I think that's current language in the code that we have not changed.
Is it? Okay. It's not in this area, but some other area?
And I think it would, I think that maybe because an investigation can be brought on behalf of something that may be deemed to be misconduct in office, but is not necessarily criminal. But I think in the course of the investigation, if something further or some criminal charge needed to be fleshed out, is what I think that language is in there to try to capture. But it's in the code now.
I see.
And we've not changed that.
Where is that in the code? Under the sheriff's part?
Sheriff's, yes.
Okay. All right. And I go back. The committee will consist of 2 clerks and the Attorney General. And that's been one of the points of contention, I believe, has it not? No?
No, sir.
Okay. Is there a reason why we don't have, say, like a judge on the adjoining circuit serving as a part of that? And I'm looking at having a clerk, AG, and then some representative of the court.
We were just trying to track the sheriff's language, in which
Okay.
the sheriff's committee consists of 2 sheriffs and someone from the AG's office.
Okay.
And then in the event that, and I think, trying to keep the locals out of it, the district attorney and the judge, if and
Always.
until the committee deems something as actionable.
Criminal. Good point. Okay, thank you.
Section 121 is changing some of the language with respect to, storage of records and moving the clerk's office to a different location. We're adding in that the governing authority can move it, but they have to have the clerk's approval. With regard to storage of records, you still have to have the judge's approval to have an off-site location for storage of records. And on page 22, one thing the judges did want in there as well, in line 745, we put in an exception for anyone being able to remove a record from the Superior Court that they have in their possession, provided that judges can check those records and files out. They felt like that was important.
Okay.
Section 122 deals with, it strikes paragraph A. Is basically, I think this was written in when they started the clerk's authority, and it's permissive language with regard to some of this equipment, and we're changing that now that they shall have all fixtures and supplies necessary for proper function of the Superior Court clerk. I think that was with that language was compromised out with ACC G, and for elsewhere in that section we add in digital and electronic as means of keeping records and copies. Section 123 is striking a section. This was the old, is my understanding, an old computer system that clerks initially had called the Go Network, which is basically obsolete now and it's not being used. So we're striking that reference to that. Section 124 deals with counties in which 70% of the population lives on a property owned by the United States government, such as having a military base, and that's not counted in for population purposes with respect to pay schedules. We're striking that. We're unaware, and no one's been able to come forward with any information of it that any county that this applies to. So we're eliminating that section. Section 125 simply redefines city court as court classified as municipal court, funded through appropriations of the county governing authority. I think that with some combined governments, you have city courts that are paid for by county funds, so it's just adding clarification there. Section 126 is eliminating what I understand of it, that clerks used to be paid time ago on a fee basis, or had a fee system of payment, which no clerk as of today is being paid on a fee basis, so we're striking that. Section 127 deals with, and this was of particular interest, what the clerks were wanting. This deals with the office hours that they hold, and they would like the ability to be able to shut down from time to time when they need to be able to do in-house training. And this on page 25 deals with, in section F, states that when they have necessary training for employees, that the clerk may close his or her office for up to 8 hours during any 6-month period. So we're not talking about a great deal of time here. And then we added in provisions with 10 days notice to the public, or sooner with the approval, this is judge's language, with the approval of the chief judge of the Superior Court prior to the closing, and provided there are no proceedings scheduled in the Superior Court during that time, no trials going on. The judges wanted that language in there.
What about pleadings? You got
Yes,
you got a lot of lawyers that having the 30th day make a filing
correct.
or something, but you're
and
still.
Paragraph G right under that deals with that, and that if they do a closure like that, that it would be considered a legal holiday, and it would push the filing date over to the next business day of the clerk.
Everyone suddenly woke up.
I knows we all did. Boom. Okay. All right.
Section 128, with regard to adding in these additional abilities of digital filing and recording of information, the clerks wanted, of course, be able to be sure that they were able to pay for that. We compromised language in Section 128 with ACCG that no agreement by the clerk to acquire services, supplies, or equipment that's authorized in this section that requires expenditure of county funds may be entered unless the funds to be obligated were included in the budget of the county for the operation of the clerk's office at the time of execution, so that they're the county who's paying for it and the clerk who's maybe contracting for these services stay on the same page with each other. Section 129 was the section dealing with cases transferred up from magistrate court. There was some issue there, and what we're trying to do is create a system where the additional fees are required, and this was compromise language with the magistrate courts that now when a case is transferred out of magistrate court, that the magistrate clerk will send up the filing fee that was paid in the magistrate court, provided, and this we added this additional language, whereas before it just said between the parties the cost shall be as in other cases in state and superior court. State and superior courts were having problem collecting the fees, so we're adding this language, provided, however, that all costs and filing fees shall be paid by the parties within 30 days. Failure to pay costs and filing fees shall result in a dismissal of the transferred case unless there is good cause shown. And then the magistrate clerk shall transmit the...
When we say about the parties, I guess one of the questions that comes to mind is you have two or maybe more parties. How do you make a determination who's responsible for that? And you could have a bickering going on between parties. Would it not be the party who's actually appealing would have that responsibility?
Or sometimes the magistrate clerk does it on their own accord if they find that something is outside the jurisdiction.
Would they make a transfer or dismissal?
A transfer.
Even when there's outside, because I think you could have filing of a major lawsuit in the magistrate court as a way of avoiding the cost. It stands now they transfer those as opposed to dismissing them for lack of jurisdiction.
I understand they transfer them.
And then you, yes, sir.
I was going to address a couple of questions on that. One, in follow-up to your issue there, Mr. Chairman, is I know that my firm had a case that was originally filed by an opposing party in magistrate court, and we raised a counterclaim which was not within the court's jurisdiction. I think ultimately the cost issue came up on appeal, and I think that because of some case law that the costs actually were to be borne by the party who had actually initiated the filing in the magistrate court. But there was an issue back and forth as to who was responsible. But my concern on this, I mean, this provides for dismissal for failure to pay the cost within 30 days unless good cause is shown. Is it your intention that that be retroactive to any cases now pending?
No, I don't know that we could do that.
I don't know that you couldn't. I'm just wondering if would y'all be amenable to an amendment that would basically say that provision is not retroactive?
Wait, yeah.
Okay. That it's not?
Yes.
That's fine. It's not the intent to try to go back and capture cases.
One last question with that dismissal. Would that be a dismissal without prejudice as opposed to prohibiting the party from bringing the action again? I know you have.
Yeah, I think that would be the intent. We're not trying to.
Well, but what if it's an appeal from a judgment of magistrate
I was just going to say, if it's an appeal from a judgment of magistrate court and you dismiss it, then you may have a judgment on the merits.
Good point.
Correct. And
all right. I'm sorry to be interrupted.
I think this is intended just to deal with transferred cases, not appeal.
Please proceed.
Section 130 just basically deals with the table of fees Superior Court clerks have to keep in their office. It says that they can keep them in an electronic format that's accessible by the public. Section 131 just clean up language. Instead of listing out solicitor general, we just refer to them as prosecuting attorney. Section 132, we are striking the section that to try to reflect current practice. All the books and logs, jail logs and stuff like that the sheriff's required to keep, they're already, we had went back and forth with some language about possibly making the county records manager have those, but it turns out that not all counties have those. What's current practice, I think, is that sheriffs are keeping their own log books and stuff, so we're striking that section there to reflect current practice. Section 133 deals with where and how clerks are supposed to keep the records, and we add paragraph E down at the bottom that states that they can basically keep them in any other electronic imaging medium that facilitates retrieval via electronic means, and provided they're able to be converted such that they can keep a computer-based backup of all archival documents. Section 134, with respect to recording, except as for documents electronically filed under the Chapter 12 of Title 10 is the Electronic Signature Document and Signature Act. And then goes on to say that deeds, adding in cleanup language that the original instrument is the instrument that shall be submitted to the clerk. Section 135 deals with recording of plats and copies of plat, just adds that they can be received and maintained in digital format. Section 136 deals with deeds to land, adding in again that deed to land the filing shall be an original document. Section 137 deals with the cancellation of mortgages, that the clerk can manually or through electronic means record across the face of the instrument the words satisfied and cancel. Can manually or electronically make a notation on the record of the mortgage to indicate that it's been canceled. Section 138, we're adding in, this is bonds that before, when you release a lien against a property, before it said, the language just said by filing a bond in the office of the clerk, but later on it actually requires approval by the clerk, so we're adding in the language that you discharge the lien upon approval of a bond by the clerk of the Superior Court. And down below it talks about it's got to be twice the amount of the value of the property, or cash bond can be accepted, or it can be the amount of the actual amount of the lien if it's a owner's domicile. And we're adding in that an owner may be required to provide supporting data of the value of the property before the clerk has to approve it. And then on page 30, Section D was the compromise with the trial lawyers, where we add in Superior Court clerk, which already have immunity from discretionary acts, shall be held harmless for good faith regarding any discretionary act in connection with approval of the bond. Just re-emphasize that they have immunity for any discretionary act. Section 139, relating to state printing of documents, adds in that may be made available. Those documents may be available through electronic means. And the Section 140 relates to title to records and access of records of constitutional officers. This language we're adding down at the bottom that as for this code section, because there's can be up to a 25-year limitation on these records, to access to these records. We're adding that under this section, constitutional officer means governor, lieutenant governor, secretary of state, attorney general, school superintendent, commissioner of insurance, those commissioner of agriculture, and commissioner of labor, because sheriffs and Superior Court clerks, their records are already available from the clerk's offices in the counties where they run. Section 141 changes the people who get together to determine the standards for microfilm in the state. We're proposing that Superior Court clerks, since they handle all the microfilm in the state, and the Judicial Council of Georgia be added as the parties who get together with respect to that. Section 2.1 is just renumbering, actually striking the 15692 as the fee system.
Let me go back to that 1-41. Does the Council of Superior Court Clerks of Georgia and the Judicial Council of Georgia have staffing capable of doing that, or is that something you have to expand your staff, or what are we saying?
That's a decision that can be made by the members in consultation, quite frankly, with the Georgia Superior Court Clerks Cooperative Authority.
Go ahead, I'm sorry.
Section 2.2 on page 32 is just on 1095. We had, because of striking a section earlier in the bill, we've eliminated the need for paragraph D, so we're striking that. Section 2.3 is renumbering because of, as is 2.4, because of the consolidation and the elimination of some of the provisions earlier in the bill that we've talked about. 2.5, essentially the same thing, renumbering, and there's elimination of a reference to the fee system. Section 2.6 is eliminating the reference to, this is dealing with the sheriff filling the vacancy or office of sheriff, which is this is striking the language that referred back to the clerk section because they have their own section now. Section 2.7 is just renumbering and referring in the sheriff's code where there was a previous referral to Superior Court's code section. We refer back to the sheriff's 15, 16, 26, which is their removal provision, which is the same for 2.8. Section 2.9 is really just a rewording of the same. There's no substantive change, just rewording of that section. And 2.10 is just a striking and of the referral back to the Superior Court clerk and adding in the reference to the sheriff's removal section as section 2.10 applies to sheriff.
All right.
That is a brisk run.
A lot of work
again,
there.
Through that.
A lot of things covered in that one area. And have questions of committee members. Ms. Oliver?
Direct your attention to page 20. A couple of questions. Line 575, which says the governor shall pay for the investigation. I assume that includes attorney fees, expenses necessary would include attorney fees.
Yes, this is what we're doing in this section here is tracking existing
Has the sheriff? Has this been used to remove a sheriff? It looks a little cumbersome to me. So, has this exact process been used?
I think you're Clayton County Sheriff. Am I right? No?
The investigatory part has been used in terms of committee of fees. Yes, several times before.
Okay.
On line 587, it looks like you're beginning to track the language that you struck on 662 through 665. So it looks like the investigation process really is duplicative of a judge starting the process. Am I correct? Am I reading that correctly?
That was an amended accepted from the Superior Court judges themselves wanting to stick that language back in there. I think they wanted I think what they wanted a safeguard that they're involved in the process, which I submit that they would be, because after an investigation is done, if the governor feels removal is necessary, then the DA initiates a removal petition, which is filed in the court, which is tried in the court, which is overseen by the judge.
What's confusing me a little bit is it says on 587, after the filing of such petition. That doesn't imply that the investigation has been completed. It just says to me that the judge's opportunity to act based on sufficient cause is only triggered after somebody files a petition but doesn't have to be processed. Am I understanding it correctly? So the judges have an opportunity as set forth in the original law only if a petition has been filed by a third party.
Correct. And I think the clerks are wanting, whereas the original language, it's kind of confusing in the original language as to whether a judge could just pull a clerk or remove a clerk. It basically just says maybe subject to removal by the judge of the court for sufficient cause.
And then the charges must be exhibited to the court in writing, facts tried by jury, and then you restate all that language. But in terms of the process, the judges can maintain that right if a petition has been filed by a third party.
Correct. What we're trying to add is a little bit of kind of like due process with an investigation and then a recommendation that's then subsequently followed through by the DA and the judge of the county in which the clerk serves.
All right, thank you. Yes, sir. Mr. Crawford.
Okay.
I have a couple of curiosities and a problem I'd like to address to the presenters. First of all, on page 8, subparagraph 6, beginning on line 240, this has to do with maintaining publications of the code and such. As I read the existing language, the code, the clerk has the discretion not to maintain this separately, but simply to designate, oh yes, our county's collection of these items is maintained in the county law library. Is that correct? So that they can avoid maintaining a separate collection of these various publications simply by designating the county law library as the repository of these documents. Is that correct?
You're talking on line 242?
Well, what I'm getting at this, I'm curious as to why we've inserted this language about allowing these things to be paid from law library funds if the clerk is not maintaining them separately.
Well, I think that I think it basically just boiled down to a lot of smaller counties and all that have funds sitting in these law library funds that frankly just could be used for the payment of these type of documents. I think was the intent to add that as an option.
But do we have any information on the number of clerks that are trying to maintain these documents separately rather than simply deferring to the county library?
No, I don't have any.
Okay. Second curiosity, on page 29, this is section 1-37 with regard to the cancellation of security deeds. When it says that the clerk shall manually or through electronic means record on the face of the instrument of the cancellation, could you clarify for me just a little bit exactly what that means? I mean, if there is a deed book on the shelf with a security deed in it, the clerk would still manually enter the cancellation on the face of that document, correct?
Yes.
So the electronic part is just talking about if there is no physical deed book.
That's correct, which is the direction we're moving.
Okay. Which brings me to my problem. We have, and Representative Maddox and I have discussed about this before, but as I read it, and I'm referring to page 11 at the very end of section 1-10, and then also beginning at the bottom of page 28, section 1 oh, excuse me, that's the wrong reference. I lost my page. Bottom of page 30, section 1-39, with regard to the grantor and grantee indices. Now, as I read the language in this bill, this would authorize the clerk to never again print a grantor or grantee index at all, ever. Is that correct?
Yes.
I got a problem with that. And I understand, particularly in the larger counties, why reprinting the index is a problem. I get that. And I want to be sensitive to it. But I also have seen occasions where title examiners go to counties and they have to sit down and look at the computer and the computer's not working. And then they have no access at all to, and not only once we get a ways down the road with this, they wouldn't have access to any property records for potentially a period of several years if the computer happens not to be working at the time that they get there. And I, prior to obtaining my status as recovering lawyer, I've experienced situations like this as well. If the computer just happens not to be working, that's just too bad. So my question is this. The law as I currently read it requires the clerk to print an index at least every 30 days. Is that correct?
Yes.
Would there be a problem in backing off of that and requiring, say, like every 90 days print an index, but otherwise have it available electronically? Is that acceptable?
You answer.
Yes.
Answer the mic so we have.
Yes. I will tell you that, first of all, many clerks will continue for the foreseeable future to have printed indexes. They will only stop having printed indexes when they feel, quite frankly, that their local constituency is ready to accept that and that these records can be accessible. The deed records are accessible from any computer at any place at any time because of the 24-hour, 7-day-a-week access to the Georgia Superior Court Clerks Cooperative Authority. So we find it, I mean, I would argue that one computer being down is not going to limit the access to these records. We think it's important to recognize that we are now in the 21st century. This is a very burdensome, it's very costly to print these indexes. You know, quite frankly, we would prefer to keep the language as it is. It'll be up to the committee. I can assure you, however, that every clerk in the state is not going to, subsequent to this bill's adoption, should it be adopted, run out and stop printing. They are, many of them, as attached to the paper as you are. We just wish to give those counties where both the clientele of the clerk's office and the clerk can arrive at a decision to begin to have access to these online.
All
and
right.
they are available. Every
Run
computer.
short of time. Any further questions, Mr. Crawford? Okay. Anyone else have questions of the presenter or Mr. Holloman? We thank you, and let me ask one question, I guess it comes to mind while we're sitting. We're talking about in here several times the fact that the old law about fees is eliminated. Do clerks receive anything as far as direct compensation as fees, which is only kept by them any longer?
Not in relation to their specific duties in their statute, but yes, they do receive fees for those clerks who serve as passport agent.
How does that change for what they're doing as a clerk? Where does that change?
It's under federal law. I mean, it's in Georgia code that allows them who have been designated by a federal agency.
Well, other than that, there's nothing
No.
else. Okay. That's all I have. Thank you.
Thank you.
We have several people who also have signed up to speak on the bill. I believe Michael Picaro, you got to speak. Come forward. And Judge Boyette, you also wish to speak. You want to come up at the same time?
Well, I can, but actually,
Separate?
the amendments that we were asking for, I believe, the clerk agreed to.
All right. No problem. No. That's not a problem. If you're okay with it, that's fine. Yes, sir.
I'm here on
You're on. You're on. Oh, I'm sorry, you're not on. My mistake. You're on.
Sorry. Again, I'm here on behalf of the Judicial Council. The Judicial Council has taken a look at this bill over the last several weeks and has had, because of the sweeping nature of it and the interrelation of Superior Court clerks, obviously with the court and with the judges, there are many provisions that we've talked with the clerks about. I think we've narrowed our list of issues from 3 or 4 pages to about half a page at this point. But I think there are several provisions that still concern the majority of the classes of courts, which including state court, magistrate court.
Why don't you go through those for us?
All right. Very quickly, in section 1-6 relating to vacancy, that provides for 2 methods of appointment, which could, those provisions, under those provisions, we could see a circumstance arising where a probate judge could appoint a valid interim clerk as well as the Superior Court. So you could have 2 validly appointed clerks at the same time. That actually exists under the old language as well, so that's not a major problem, but it would be something to look at. Section 1-19 relating to contempt. We had worked out a general solution to the contempt power but under Section 119, the concern of the classes of courts is that the specific reference to the Superior Court judge's contempt power under 15.6-8 is in there, but none of the other classes of courts.
Do they have contempt power outside their court and their court orders?
At least the statutory scheme is under 15.1-4 is the subsection A, subparagraph 2. All courts have the general contempt power over.
That's my question again.
Yeah.
Do, under these sections, the courts have contempt power outside of their court and outside of their court orders?
Not that I understand, no. I'm not an expert in contempt power.
Just I don't think they do. I mean, you'd have to have something that's happened as a violation of an order or something happened within the confines of their courtroom where they say your conduct is in contempt.
That's part of the problem with all of the changes. There's many moving parts in these sections. For instance, section.
I think that's kind of what the intent of Superior Court clerks are wanting to get at. That they don't want to be subject to, somebody thinking a judge that thinks they can hold them in contempt of court if they're not acting in that court or clerking for that court.
Okay. We have no problem with in fact, we've talked with Gene Rogers.
Well, I guess I'll say we have here what is a statutory scheme of the court as to the conduct of what's being done by its clerk. It is its clerk, the court's clerk, although separately elected, to be sure they are handling the work responsibly as required by law. So and the only thing you'd have otherwise would be by action removal, correct?
Contempt or removal.
Yeah, well, contempt would only be, again, as I say, those sections deal with what happens in their courtroom or by what their orders say. If you don't have something of that nature, there is no other way the court finds someone in contempt, unless statutorily it says so, right?
If I may, the general contempt power of a court is to sanction misbehavior in official transactions of a court officer. That exists under 15.1-4. However, when you take out, when you remove subpart or paragraph E of 15.6-62 under section 1-11, you're actually removing the court's power to hold a clerk in contempt for failure to discharge their duties, and that also includes removing the ability of a judge to send the matter to a grand jury for investigation.
Okay.
So the question is...
I got some concerns there. Okay, go ahead.
So those are some of the moving parts. Section 1-10, which says that clerks must do their duties as enumerated by law or in court rule or order. I have concern that that may abrogate the current state of the law, which says that a court may issue an order orally, and if it's not followed, they can hold the court officer in contempt.
Mm-hmm. Okay.
Section 1-20, which relates to removal, Judicial Council echoes Representative Oliver's concerns with that. I think, again, the perspective of the majority of the classes of court is that this is a matter that should be within the province of the courts themselves and the judiciary. We've offered to talk about due process considerations to flesh out the existing process, but again, we've not. I think people have been holding tight to the current provisions. Section 1-27 again relates only to permission to close court from the Superior Court judges, and may not, under the current draft, does not offer that same sign-off to the other classes of court served by the Superior Court clerks. Section 1-41, which relates to microform standards, currently says that the Administrative Office of the Courts offers their concurrence to the State Records Retention Committee. The clerks that is a process that involves clerks. Now we've done with retention schedules. It is the duty of the Administrative Office of the Courts to offer changes to improve the efficiency of the courts, and we don't believe that the clerk should work through our process and then work through their process, thereby complicating government one bit further.
Who's on the State Records Committee?
I don't remember. I believe that's run by Archives, though.
Okay.
We just finished a multi-year records retention review about a year ago, and that didn't include the clerks.
Other points? We'll run short of time.
I understand. I believe that's enough.
All right. Anyone else wish to speak on House Bill 665? Not the chair will close off further public comment. You want to speak?
No, sir. I'm Mary Catherine Catherine Moss. I'm president of the Council of Magistrate Court Judges. We reached an agreement. I know that there were some questions about that. I just wanted to let the committee know I was here if there were any current concerns or questions. Thank you, Mr. Chair.
Thank you. Mr. Hatfield?
Well, I just have a couple of amendments.
Well, let's wait till we get motions if we could. First of all, do we have a motion? Then a motion do pass. Is there a second? Second. And there is a second. Do we have any other discussion on the motion? Mr. Jacobs.
Mr. Chairman, I'm going to make a substitute motion. I have the utmost respect for Chairman Maddox, but I mean, there are a number of issues that have been raised with regard to this fairly lengthy bill. And we're now, 2 legislative days, about to be 1 legislative day prior to crossover day, and I'm not sure that, that there's going to be sufficient time to work out those issues, prior to this bill going over to the Senate, and then who knows what happens to it over there. So I'm going to make a substitute motion in complete respect to Chairman Maddox. I'm going to make a substitute motion to table the bill at this time.
All right. We have a second to the motion to table.
Second.
It's been seconded. That is a motion that's non-debatable unless you have comment about it. I think you're right as far as the issues we have still hairy in there. Chair will take up the motion to table. All in favor of motion to table signify by saying aye.
Aye.
Opposed?
No.
Motion fails. We go to the motion do pass. There was a motion and a second to that, as I recall. Ms. Oliver, you have.
I'd like to make an amendment, offer amendment, Mr.
All right,
Chairman.
we will let you light up for all amendments, if you will. Let me get Ms. Oliver's in. Ms. Oliver, go ahead.
It's my intention to provide the Superior Court judges with an alternate matter, and there not be a contingent that the petition be filed. That's my intent. And my amendment to accomplish that is on line 587. Insert the words "in addition to filing such petition." So I would take after the, in addition to filing such petition. This is page 20, line 587. In addition to filing such petition as set forth herein, a clerk is, comma, so it would read, in addition to filing such a petition as set forth herein, comma, a clerk of Superior Court is subject to being removed from office of the judge of the...
What line was that again? I'm sorry, Ms. Oliver.
587 on page 20.
Right.
And the purpose of my amendment is to give the judges an alternate method without there being a contingency of the petition having been filed first.
All right. There's a second to that motion?
Second.
We have a second. Any discussion on the motion to amend First Amendment?
Ms. Travis looks concerned.
Pardon me?
Oh, I'm sorry.
It is 687.
687.
It's hard to read those numbers on it. It is 687, Ms. Travis. Excuse us. Have it repeated for her benefit then.
I'm eliminating the words "after the," and I'm inserting after such petition the word "as set forth herein." So it shall read, in addition to filing of such petition as set forth herein, comma, a clerk of Superior Court is subject to being removed.
587.
687.
687.
I'm trying to set forth the process that's set forth
This section?
in 15682, I think, is what I'm trying to do.
Make it this section then.
Yes, sir.
Code section.
That's preferable. Thank you, Ms. Travis.
Did we have a second? I wasn't clear. We have a second? Okay. Any further discussion on the Oliver amendment? If not, the chair will call the question. All in favor signify by saying aye.
Aye.
Opposed, like sign. Thank you. Let me mention to the committee, the chair has heard that the speaker is holding up a roll call, so we're not under a time pressure to be into the roll call. There will be other things, I'm sure, business-wise going on the floor, so I'd like to continue in our meeting. Mr. Crawford.
Thank you, Mr. Chairman. I would like to propose two amendments. It's actually inserting the same sentence in two different places. First place is on page 11.
We're taking the separate amendments.
Page 11, line 366. At the end of the existing line, insert a sentence to read as follows. Provided, comma, however, comma, that complete, comma, printed copies of the real estate grantor and grantee indices shall be prepared no less than every 180 days, and any correction made on such index shall be made a part of the printout and shall reflect the time and date that said index was corrected, period.
That's a big amendment. Do we have a second, first of all, to the Crawford Amendment number 1?
Second.
It's been seconded. And in discussion, does everybody understand the amendment?
Briefly, Mr. Chairman.
Pardon me?
If I may, Mr. Chairman.
Please.
I carried the bill 2 or 3 years ago, which required that these records be placed online, and that's already in effect. So I don't believe that the concerns regarding the computer being down is something that we need to be worried about at the present state, given what the law requires that all these records be online.
Well, it's an issue when you've driven 2 hours to get to a clerk's office and you don't have access to anything else and the computer doesn't work. And I think twice a year to print an index is not a big requirement.
All right, we have discussion as to that point, and now we will call the question. All in favor signify by, this is on the Crawford Amendment number 1, all signify by saying aye.
Aye.
Opposed, like sign.
No.
Chair is in doubt. The chair will call for a show of hands. All in favor of the Crawford Amendment number 1, signify by raising your right hand. Chair will make a count. 1, 2, 3, 4, 5, 6, 7, 8. And all those opposed, like sign. 1, 2, 3. Motion carries. Amendment number 1. You have another amendment, you said?
Yes, Mr. Chairman. It would be to insert the same sentence.
Let's call for location, please.
On page 31.
31.
At the end of line 1046.
State your amendment.
The same sentence as the last time. I'll reread it if you desire for me to.
Read it.
Okay. Provided, comma, however, comma, that complete, comma, printed copies of the real estate grantor and grantee indices shall be prepared no less than every 180 days, and any correction made on such index shall be made a part of the printout and shall reflect the time and date that said index was corrected, period.
Yeah. May I inquire, and it probably goes to the other one too, I was listening and writing at the same time earlier. You're saying every 180 days, that changes from year to year, you know. I'm questioning why we don't make it every 6 months, at least every 6 months.
I am certainly receptive to that, Mr. Chairman. In fact, I contemplated making it current through June 30 and December 31 of each calendar year. And I would be receptive to that language. The only problem is some of the jurisdictions can sometimes run quite a bit behind in preparing the index. But my only point is to try to.
What would you prefer as far as trying to use dating of every 6 months, 180 days, specific dates?
Well, I think you might have some input from the clerks on that one. It seems to me like if you have a date certain, it might be easier than if you said every 6 months or every 180 days. But instead of having to calculate, you have something set in stone.
All right. Is that preferable?
I actually
look at your clerks.
Seem to have a preference.
All right. Let me suggest we use the June 30, December 31 dates as the appropriate date for both this one and the previous Crawford Amendment number 1, as opposed to every 180 days. Is the committee accepting of that? They want to object
Absolutely.
to it? we'll do that on your Crawford Amendment 1 and 2, if I might. So direct. Okay? You're going to have to get a copy of that to her because she's not able to write it down. And it will be subject to punctuation all as reviewed by Legislative Council. All right, sir. Crawford Amendment number 2, is there a motion? There's been a motion for that. Is there a second? Second. It's been seconded. All those in favor of the Crawford Amendment number 2 signify by saying aye.
Aye.
Opposed, like sign. No. The chair rules. The motion carries. Any further amendments, Mr. Crawford?
No, sir.
Do we have a motion for amendment by Mr. Hatfield?
Yes, sir. I have two. On page 17, at line 591, by striking the word 5 and returning it to 20 years.
Second.
All right, there's been a motion and second as to 591, line 591 of section 1-15 to replace the stricken 20 back to 20 and take out 5.
Right.
Okay, there's been motion seconded, and the chair will call for the question. The Hatfield Amendment number 1, all in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Further amendments, Mr. Hatfield?
Yes, sir. Mr. Chairman, on page 26, at the end of line 888, I would like to add a sentence that reads, "This code section shall apply only to actions filed on or after the effective date of this act."
Second.
On line 388. Is that where you were?
888,
88,
Mr. Chairman, at the very end of that line.
All right, we have a motion and seconded as to the Hatfield Amendment number 2. Any discussion on the proposed amendment? If not, all in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. No further amendments, Mr. Hatfield. We have a proposed amendment by Mr. McKillop.
Thank you, Mr. Chairman. At line 1035 to 1037, I would like to strike section D. It provides for immunity, well, held harmless for good faith, which I don't know why you would need to be held harmless for good faith, but of discretionary acts. And I know there's some type of immunity either for governmental or discretionary or administrative acts, but I would make the motion to eliminate section D at 1035 to 1037.
Is there a second to the McKillop motion? There being no second, the motion fails for lack of a second. We have other proposed amendments. The chair would like to go back and look at the language again as to the contempt question. I still have some concern because the only time you could have contempt by a court under those reference sections, I believe, I haven't looked at them specifically, I don't know what else would address. What was that section on, Mr. Maddox? That we talked about that.
Section 119.
19, yeah.
On
Page 19, section 119. I would like to entertain a motion to have section 119 stricken as a section. I think that there is potential need from time to time, if ever used not, but at least to have the courts recognize that the work performed is required of the clerk, and to fail to do so may be subject to address it by the court of contempt. Does anyone have a motion they wish to make on that?
I'll move it.
It's been moved. Is there a second?
Second.
And seconded. Any discussion on the motion? The motion is to strike section 1-119 and renumber past that section. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Any further amendments? Now we call for the main question, which is a motion due pass on House Bill 665 as amended, committee substitute. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. We have one more bill, which is HB 861, Representative Hardin's bill. He's outside. You bring him in. We'll have you come around, Representative Hardin. Please, sir. Crawford, get your language to Ms. Travis, please, legibly.
In writing. We don't want it electronic. You don't want to vote on
Okay. Yes, sir. Mr. Harden, you're here on House Bill 861.
Yes, sir, Mr.
Please
Chairman.
present it to us.
Thank you, Mr. Chairman. Just to make sure we're on the same page here, I'm on LC 35-2650, S as in Sam. It's a substitute.
I think we're off numbers, and we got a oh, I'm sorry. Yeah, we did have a pass out, which is LC 35-2650S. Does everyone have your copy of that bill?
I did not.
Just a second. We're supposed to have had a pass out.
Okay, it might be a 25-660.
You got it? All right. You have yours? You don't? You need one over there, too. All right, sir. Please proceed, Mr. Harden.
Thank you, Mr. Chairman. House Bill 861 is a bill that I've been working on for a few years that will require drug testing for all applicants and recipients of state-administered TANF benefits. I'm going to very quickly run through the bill, and then, Mr. Chairman, we'll take your lead from there. Section 1 simply outlines the intent of the bill. Section 2 has several parts to it. Section 8 provides for general definitions. Let's see here. B, testing guidelines, which are upon application for TANF benefits, and then random, not less than once every 2 years. There was a section in the original bill dealing with law enforcement reporting drug arrest to DHS, but we've taken that section out entirely, so we are down to just two simple guidelines on testing, once upon application and then once at random after the fact. C on Section 2 provides for safety resource to receive benefits for children, meaning that if mother or father that are receiving TANF benefits fail a drug screen, under this bill, the TANF benefits are going to continue to go with the child. DHS will administer the same safety resource process that DFACS currently does to ensure that that TANF benefits in this state are going to those that they're intended for, and that are the children. So D, Section D under Section 2 deals with conditions for appeal within the Department of DHS. All appeals and administrative hearings will remain in the department to protect the privacy of these individuals. At no point will their drug screen results be shared with any other department or used in any civil or criminal action. This is simply to get them on the radar screen, get them help, and make sure that their families, in lieu of their children, are receiving these benefits. E under Section 2 is dealing with the cost and how that will be administered. It'll be a cap of $40 per drug test. DHS is telling us that it's somewhere around $23 to $27, so 40 is worst case scenario, and that will be deducted from their benefits over a 12-month period. So you're perhaps talking $3 a month withheld from their benefits. F on Section 2 deals with the disclosure of those results and the privacy, and the fact that, as in Section G there, all records will be destroyed after 5 years of the test. Again, this is not to play a game of gotcha. It's not to hold anyone guilty of any civil or criminal liability. It's simply to get them on the radar screen, protect the taxpayers of this state, and ensure that the children are getting the intended resources. So that's a quick one, Mr. Chairman. I'll be open to whatever you want to do.
All right, I think we have some questions of the presenter. Mr. Bruce.
Is the presumption that people that are getting money in this program, the presumption that they're using drugs?
No, sir, Mr. Bruce. I appreciate that question. That's one that I've gotten before. That is not the presumption. My hope is that we will have no positive drug screens. This is not insinuating that anyone is more likely to do drugs than anyone else. It's simply stating that if you are going to sign up to receive benefits in the form of taxpayer dollars of this state, all we're going to simply ask of you is to live by the same set of rules that those that pay the taxes live by every single day when they go to work and submit to random drug screens.
I mean, but everybody doesn't submit to random drug screens. In fact, I would presume that based on the 30 years I've spent in human resources, most places don't have a random drug screen.
But it is there if their employer wants to implement it, and this is the same situation. We are just going to ensure that those on the receiving end of these benefits are held to the same accountability, and in some cases, as you know, I trust that you know for which you speak, but that it's protecting the taxpayers of this state and it's getting these folks on the radar. A lot of these folks, mind you, may not be plugged in anywhere else. Obviously, they're not at work. They may not be plugged into a church group or any other groups, and so there may not be anyone to witness adverse behavior. And so this is going to ensure that, if someone does fail a screen, which I hope that they don't, this is going to put them on the radar screen so we can get them some help.
All right. One last question, though. Okay, you wave. Okay, Ms. Oliver?
The Florida statute that's been enjoined, of course, based on constitutional issues, I believe provided that the recipient would pay for the drug screen only if the drug screen were a positive drug screen. Am I remembering that correctly?
I recall something similar to that, but I don't believe that ended up being the case in the final bill, but don't hold me to that. I may be wrong.
And that's not your intention here?
No, ma'am.
So your intention is for the state to assume only the administrative responsibilities, the logistics, the bureaucracy of it, but not the actual cost of the drug screen.
My intent is to put no additional burden on the taxpayers in that case, the cost of administering tests.
Don't you recognize there would be an additional cost to the taxpayers based on this additional contingency for applications?
I do, but I also understand, or it's my belief, that that cost would be offset by potential savings.
And you don't have any evidence, or if you do have any evidence, tell me, about what that cost of savings would be, or what the percentage of TANF applicants would result in a positive screen. Do you have any evidence of that?
There's studies out there, but I could throw a half a dozen at you, and you could probably find a half a dozen to the adverse. Indiana, I believe it was, Indiana or Illinois, recently did this a couple of years ago, and they had a recent study by, I believe, Duke University that had 8% of America, 8% of general population, if you will. If 8% of those on TANF benefits are doing drugs, then the potential savings of 8% of a lot of money is a lot of money. So.
But 8% of state employees would be similarly based on your evidence that would also be using drugs.
Well,
is that
like
correct?
I said, that's not true evidence in the fact that it's hard and fact, but it's it's one of those studies that are out there.
I don't remember whether the administrative appeal process that you're placing internally in DHR was in the original bill or whether that's new in the substitute.
No, ma'am, it was in the original bill. The only thing different in this substitute from my original bill is dealing with Section 2, which was the reporting of law enforcement of drug arrest to DHS. That's been the only change.
I'm not really sure that your privacy rights are protected in the way you assert is the policy reason for leasing that in DHR instead of moving it to OSHA where all the other hearings are. Is this comply with the same privacy protections that are for AIDS patients or for mental health records? Do you know specifically?
I do not. It's my understanding in a general concept that it does. I will tell you that one of the greatest reasons for leaving it in-house was part of the opinion cited in the Florida case, and that was dealing with basically positive drug screen results getting out beyond the department. As I've stated, it was not the intent of this bill to punish anyone. It's simply to protect the taxpayers of the state, make sure the kids are with a safety resource, they can continue to get that help, and make sure that the parents are on the radar screen.
Final question, Mr. Chairman. I do have a legal opinion from Legislative Counsel. I believe I gave it to a colleague, Ms. Stevenson. To save the taxpayers' money, Mr. Hardin, I think that this bill should not go forward because it will be declared, in my legal opinion, unconstitutional, just as the previous bill, state employee was declared unconstitutional.
Let's try to leave the questions. I'll come around to my left, Mr. Hatfield.
Thank you, Mr. Chairman. In my review of the bill, one thing that concerns me is maybe the bill doesn't go far enough, and I've got concerns about social welfare, but I've also got some concerns about corporate welfare. And I'd love to see the bill amended so that those who receive the corporate welfare from the state would be subjected to the same requirements.
Might be a bill for you to draw up next year. Sorry, Ms. Dobbs.
Thank you, Mr. Chairman. My question is that should any of these individuals fail the test, are there drug rehabilitation programs in place at no cost to these individuals so that they can turn themselves around and get back
Very good question,
receiving the
Representative Dobbs. Currently, DHS, or I'll refer to them as your local DFACs. If someone is receiving TANF benefits, there are two sides to your local DFACS office. There's the ongoing, which deals with DFACS cases of abuse and that sort of thing, and then there's the TANF side, which is administering state dollars in the form of temporary assistance. Currently, within DFACS, there are policies that if someone fails the drug screen, they work what they refer to in the department as a safety plan. It's a checklist of events, things that they have to achieve before they come out from under the umbrella, if you will, or oversight of DFACS. So, yes, if someone fails the drug screen, it will trigger that already in place DFACS policy of putting them through the proper channels.
One more question, Mr. Chairman. And also, do you have any data on the budgets and the financial situation on these individuals on the TANF program, and should they lose their benefits for themselves personally, how will that affect their children, and will they be able to maintain their homes and keep their children, and if not, how is this going to affect our foster care program in Georgia, and how much money is that going to cost the state?
Well, if they are using drugs, my argument would be that their children probably aren't benefiting very well from their TANF check every month anyway, because I don't know many addicts that are very good at budgeting, this for the children, and I'll use $200 this month for my dope budget. So I think that this is going to ensure that the money follows those children, and when they're put in a safety resource, which 9 out of 10 times are relatives, it is going to make sure that the children are getting that needed money. Now, in the case of someone possibly losing their housing, in this case, I would argue that it's not because we are testing them and that we're holding them accountable. I would argue that it's because they're participating in illegal drug behavior.
Thank you. Next is, I'm not sure, is it?
Mine is on.
Yours?
Yes.
Okay, you're on.
Mine is on. Okay. Thank you. I have some serious concerns on the recitals, particularly those that are on line 15 and 21. And 18 as well. My first question to the author is, do you have any data that suggests what you set forth in order to, I believe that's your starting point for your individual suspicion, so that it's not in violation of the Fourth Amendment? Do you have any such data that would suggest that TANF recipients are more likely to use drugs than the general population?
I don't have any studies with me, but obviously there are several. If you speak with local law enforcement, if you speak with DHS, I mean the numbers are prevailing and they're out there. It's not a matter of a blame game or trying to play gotcha. It's simply that folks that are desperate, if you will. In this case, we're talking about that section there. Is dealing with folks that are using illegal drugs. We know that those that participate in that type of lifestyle tend to not have, very tight parameters.
Well, Mr. Chair, may I reframe that question? Do you have any direct evidence that those that are recipients of TANF benefits, being poor, or are more likely to use drugs than any of the general population, including people in this room?
No, ma'am.
All right. Okay. Thank you. Next, Ms. Evans.
Thank you, Mr. Chairman. I wonder if you could just clear, I have some confusion, and it may end up just being my own confusion, but my understanding is that TANF dollars are federal dollars, so I'm having a hard time understanding how us passing this bill is going to save us in Georgia, save the Georgia taxpayers any money from a state perspective.
Well, TANF benefits are not entirely federal dollars. I believe what you're referring to are food stamps. Food stamp money, 100% of food stamp money is USDA, which is federal. Half of the administrative costs are state, half relies on the feds. However, what we're talking in regards to TANF benefits, say if someone goes to their local DFACS office and they say that their power is about to be turned out and that there's children in the home, the state of Georgia through DFACS has determined that sometimes it's better for them, the children and the taxpayer, to pay that power bill, if you will, to keep heat in the home in the winter months, rather than open up a case and go through the steps there. So you're correct in regards to food stamps, but TANF, which is a temporary assistance for a broke down car, for a power bill, a gas bill, that sort of thing, those are state dollars.
If I might follow up on that, using the example that you just gave us, you need heat. It's the winter. It's freezing outside. The car's broken down. Mom needs to get to work. Kids need to get to school. How long do you expect that these test results are going to take to get back? And so, aren't we undercutting the entire purpose of the program, which is that temporary fix to get the family through the hard times? Aren't we cutting them off at the knees and not giving them a chance to deal with what TANF was meant to cover?
Well, no, ma'am, we're not, because they would not be cut off, in your words, of those benefits until a positive test result came back. So, only then would that trigger that. And at the end of the day, we're going to make sure that those children do get the tax dollars that they're deserved, and that is the intent of this state through TANF benefits. My argument is, if someone's receiving TANF benefits or any public assistance in this state, and they're testing positive for illegal drugs, then clearly they're not being a very good steward of the tax dollars, and it makes me question how much heat and how much gas is going to be in the car in any way.
Let's go forward, because we are running very tight on time. It's almost 10:30. There are several people who want to address the committee, and I'm going to go in the order they signed up. First will be Wayne Drummond with the Georgia County Welfare Association. Mr. Drummond. If you have a handout, just pass them over here, and we'll get them passed around to the committee.
Thank you so much.
Yes, sir.
Mr. Chairman, members of the committee, my name is Wayne Drummond. I'm with the GCWA, Georgia County Welfare Association. Wanted to speak to the extra responsibilities caused by this bill for the department and the people that do this work. In the Juvenile Code rewrite and in Senate Bill 312, there were some, which was to create personal responsibility for food stamp recipients. There was some clear acknowledgement that the work of people who work in the field, and I represent 1,100 folks across the state that do the work in family and children services to help people gain access to benefits. There was some acknowledgement that either by having a delayed implementation date or being contingent upon funding, that was the right thing to do. If you look at the workload in family and children services, the average caseload has doubled, which is basically a large unfunded mandate, from 379 cases on the average in 2004 to 757. They've managed the increase well. It's not been without problems. And if we layer on additional responsibilities, there can be unintended consequences. We sort of have viewed unfunded mandates as being required to teach a mule to climb a tree. We can get it up on a limb sufficiently high sometimes to do some good, but there is a danger, we feel, of causing that limb to break and having unintended consequences.
You know, we did put contingent language in here about funding.
No, sir, I did not see
there is language on line 57, which says contingent upon available funding, in addition to administering a drug test to applicants for TANF benefits, the department shall institute a random drug test program for recipients of TANF benefits, etc.
Okay, I did not.
That's recent, I think.
Okay, if that's it, then I will be quiet and thank you.
Okay, thank you. Didn't mean to cut you off, but I think we may have had that part of it answered. Linda Lowe, please come forward.
Thank you, Mr. Chairman and members of the committee. I'm representing Families First. We think that this bill would be bad public policy, that it's probably unworkable, and that it's going to be expensive for the state in ways that I'll outline in just a few minutes. This bill will burden many families in order to find a very few people who will test positive for drugs. As the author has said, people who receive TANF are not much more likely than anybody else to be using drugs. So right there you've got, a small proportion. Also, however, the Council on Substance Abuse has testified that drug tests are not a very good way to find people who are actually using serious drugs for several reasons. And I'm no expert, I have no personal experience with this, but what they have said is that while it's easy to detect marijuana use by using a drug test, it's very difficult unless somebody dashes right in pretty soon after using, that is to say within a few hours or a couple of days at best, to detect the more serious kinds of drugs like cocaine. Not that, we don't think very many people are using these kinds of drugs, but in any case you would not be detecting the ones that do have serious problems. And by the way, these families do pay taxes. They don't have very much money, and so they don't pay the same amount of taxes that the rest of us do. But if they have to go into Target and buy a pair of socks, they're paying taxes on it just the same way we are. And people who are renting a home are paying to the landlord what the landlord has to pay in property taxes. So it's not the case that these folks are not taxpayers. Apparently the bill will delay benefits until the test is complete, and this will only hurt the children. If you look at lines 53 through 56, it says clearly that where any applicant is tested, no benefits will be provided until the testing is complete. There's no provision for repaying the family for the cost of the test. And in fact, there's a provision for charging out of future benefits something that I'm not clear about what it is, but it's the administrative cost of the testing. It's not clear whether that is an attempt to charge for the test itself and or for the additional costs that the state is going to incur from operating the system. Not to mention that people have problems with transportation. It's not clear from the bill whether the DFACS offices would be setting up to do these tests, which of course would be a big burden, or whether people would be told that they have to go find a test site. But either way, it's a terrible burden on these families. A lot of people don't realize that the maximum grant for a family of 3 is $280 a month under TANF. And that is the maximum for a family that has just very little other income. So families cannot afford to have money deducted from their paychecks. I think I handed this out before, but it's still the case that even paying, $17, which is the cost for one type of test, is several meals of groceries for the family. It's probably also not widely known that there are only about 4,300 adults who are receiving TANF as part of a TANF grant in the state. So this is a tiny population of folks. There are about 27,000 children in child-only grants, but these children are already in the care of other family members.
Ms. Law, I'm not trying to interrupt you, but I realize you may be opposed to the bill. If you've got something, though, specific with the bill that you want to address, may I ask you to do that? We are running very short time-wise, and I'm trying to let everyone speak as to the bill. So if you have something that you find in here that should be addressed, please do so.
Okay, my concern is about the thrust of the whole thing, but I would like to point out that there are lots of costs with this bill, some of which have been pointed out in the question here: the administering, the issuing of notices, adjusting checks, possibly setting up drug test sites, or at least finding out where they are, overburdening already burdened county workers. And there are many people for whom the state will not be able to recoup any costs, either because they've tested positive and aren't going to be receiving a benefit, and that's going to be a tiny number, or because they are people receiving benefits for children in these child-only grants, and there won't be any check for them from which to deduct this. It could only be deducted from the children's check, which would mean it would hurt the children. So we're opposed to the bill, and thank you for the opportunity to
Appreciate
testify.
your coming before us, too. Let me just remind everyone we are running very tight time-wise. Ms. Senefit, you're next. If you could address as to comments of the bill, I'd appreciate it.
Thank you, Mr. Chairman. Members of the committee, I'll try and be brief. I'm here on behalf of the Georgia Coalition Against Domestic Violence and Georgia Women for a Change, and we too have concerns about this bill. We worry about any additional obstacles that might stand in the way of victims of domestic violence accessing TANF benefits, which are a critical component to their ability to leave an abusive situation and stay safe. Transportation is a huge issue for victims of domestic violence, particularly in our rural parts of the state, so we worry that in this case folks will not only have to find transportation to their defects office to initiate an application, they will then have to find transportation to a drug testing location, and we don't know whether that's going to be within the defects office or elsewhere. In Florida, it was actually in a separate location. But I agree with all the points raised by Ms. Lowe, but I wanted to comment specifically on some questions about the constitutional concerns about the bill. As Representative Oliver pointed out, a very similar Florida bill has been enjoined by the Middle District Court in Orlando. That injunction is currently being appealed to the 11th Circuit, which, as y'all know, is our appellate court. So hopefully within the next several months, we'll have a ruling from our Court of Appeals as to whether or not suspicionless drug testing of TANF benefits are permissible. It seems like it may be premature to be passing such a bill now, which is likely to generate some challenges if it should pass. The reason that I think that it's a concern is that Georgia has actually been the source of a couple of drug testing related cases, one of which went all the way to the U.S. Supreme Court. Y'all who were here in 1997 may recall passing a bill that required candidates for elected office to submit and pass a drug test before they could qualify. That case, the Chandler case, went to the U.S. Supreme Court, and the court said your interest in having a drug-free legislature is not sufficient to overcome the Fourth Amendment's bar on warrantless searches, which a drug testing is. So we've already brought one case to the U.S. Supreme Court, and I would encourage caution before we follow down that path again. Similarly, there was a case that just went to a district court in Georgia dealing with testing of candidates for state employment. The argument was, well, we've got an interest in a drug-free workplace, so therefore anyone who wants to work for the state of Georgia ought to be submitting to a drug test. And the court said, no, that is not permissible. Really, there's a very narrow set of circumstances in which courts have authorized a drug test without a warrant. It's cases, for example, where there's been a train wreck, and we say, well, we don't have time to go get a warrant. We need to know if those railroad employees were using drugs. So that the public safety demands that we go ahead and require them to submit to a test. Similarly, customs agents who are involved in drug interdiction efforts, we have a public safety concern for making sure they're not using drugs. Therefore, we're going to require them to submit to drug testing. The court in Chandler specifically said it is not enough just to state that you've got a reason to do drug testing. There actually has to be evidence of it. And I'm not sure that the whereas statements in the beginning of the bill are going to satisfy that requirement for the court. The court says that they look very, very closely at any effort to interfere with the Fourth Amendment's general presumption against warrantless searches. So I just urge caution in light of Georgia's history with drug testing.
Thank you, Ms. Senefit. Appreciate you coming before us. Mr. Patel, if you can be... You wave. All right, that's a good move. Mr. Hunter, Oliver Hunter with the Sheriff's Association. We did the withdrawn, that's right. I think that's all the persons who signed up, so the chair will rule there's no further public comment to be given. The bill is now in the breast of the committee. Do we have any comments of committee members who wish to make regarding the bill? The chair taking a motion. Yes, ma'am.
I have a comment.
Ms. Dobbs.
Just one question. In light of what has been testified to a few minutes ago, and understanding that it is your intent not to punish the children or the families of these possible few the folks that use drugs, have you considered that instead of removing their TANF funds immediately, should they test positive, that they be referred to a drug rehabilitation center and given a period of time in which to rehabilitate themselves from the drugs and then retested so as not to place the families and the children in these precarious situations?
I have, and that's the intent of the bill. There will be no precarious situations simply because the benefits are going to go with the children. Mom or dad, whoever that is, can get help under this bill. Mr. Chairman, if one moment, let's assume that it's not a lot of families. Let's assume that it's only one family out of all the ones in Georgia that are currently receiving TANF benefits. If there's one person out there abusing the taxpayer dollars of this state, this bill is going to ensure that not only they get help and those children are protected, but it's going to ensure that there's a family out there that needs these benefits that in a cash-strapped state that we're in isn't getting them. And another comment's been made about transportation and admin costs. The admin costs currently with DFACs are written into the cost of the test. The $17 is not only the test. A lot of that is outsourced outside of the DFAC's office, but under no circumstance does someone have to provide, if transportation is not available, these are random tests. They're going into DFACs anyway to meet with their caseworker. They'll pop them with the random screen there.
Brief, please, sir. Ms. Oliver?
I'm focused more on the cost than anything else.
Mm-hmm.
Don't you agree that waiting until the 11th Circuit rules on a suspicionless drug test will save Georgia taxpayers money that will greatly offset the possible identity of a few parents out
Chair
there?
rules that will be part of the discussion. Let's please, we're not going to have further input. I'm suggesting to committee members, if you have comments as part of our discussion, not further questioning of the presenter. That's your comment.
Yes, sir.
All right. Anyone else have a comment on the bill? If not, the chair will entertain motions. First of all, any motions? Have a move, do pass, and second it. We have substitute motion by Ms. Oliver. Been moved to table. Is there a second to that motion? Second to the motion. That takes priority. No further discussion as far as the motion to table. All in favor of the motion to table signify by saying aye. Aye. Opposed, like sign? No. Chair rules the motion fails. We're back to the main motion. The motion is a do pass on House Bill 861. Excuse me. Any amendments? Ms. Stevenson?
Thank you, Mr. Chair. I'd like to offer as a first amendment the deletion of in Section 1, lines 15 to 20, considering those are the special needs rationale for warrantless search, and the author has testified that there is no such data. So on the lack of a factual basis, I move as an amendment that we delete lines 15 through 20.
All right. Steve's amendment, which has been seconded, elimination of lines 15 through 20 of Section 1. Any discussion on the amendment? There being none, the chair will call the question on Stevenson's amendment. All in favor signify by saying aye. Aye. Opposed, like sign? No. Chair rules the motion fails. Any further amendments, Ms. Stevenson?
Yes, sir. I
All
have on line 53.
All right.
Not later than January 1st, 2015.
You want to change the 2013 to 2015?
Yes, sir.
That is a motion to amend. Then is there a second to that motion? It's been seconded. All right, you amend the amendment. All right, the motion to amend the amendment. By I think that would be an appropriate amendment to the amendment you've made, Ms. Stevenson, unless you wanted to withdraw your amendment and have that as a separate amendment. I will take that as an amendment to your amendment.
I would like to withdraw mine and make mine as a separate because there are two different thought processes there.
All right, she's withdrawing the amendment. Will not have that amendment at this point in time then. Is there anything further you wish to offer, Ms. Stevenson, as amendment?
No, but I would like to come back at the appropriate time for the amendment on line 53.
That's on 50, 15?
53. Yes, to
53.
2015
The first
again.
one you offered. Okay, well, if you, well, what we're ruling on this part, on line 53, is the fact that if you offer that, there will be an amendment to your amendment. That's why I'm suggesting.
Right. That's why I'm withdrawing it, and we'll come back to it in
All
another
right.
form.
And we have Ms. Evans. Amendment by you, Ms. Evans. You waive. We have Mr. Lindsay.
Yes, sir, I have two amendments.
State your first amendment.
First amendment would be on line 53, changing January 1 to 2013 to July 1, 2013. If I may explain, I will also be offering a second amendment regarding 125 and 126, delaying those implementation dates as well. I've consulted with the author of the bill, and he's in agreement. Let's let the 11th Circuit rule.
I was having a discussion. We're going to have, we're changing dates, and your date here will also affect the effective date.
Yes,
I suggest go ahead and make this all as one amendment to
I
include
will, Your Honor. I will.
dates. Chairman.
Mr. Chairman, I was actually able to practice law on Friday, so I slipped back to my old law. If I would, Mr. Chairman, be allowed line 53, like I said, change January 1, 2013 to July 1, 2013. And as part of that amendment, also at line 125, change July 1, 2012 to January 1, 2013, and also change on line 126, change January 1, 2013 to July 1, 2013. The case that Ms. Oliver references is presently in the 11th Circuit. We should expect a decision sometime in the next few months, and that puts the effective dates after the time in which we'll see an appeal, and also after the next legislative session, should we want to look at this again.
That is the Lindsay amendment. Everyone understand the amendment? There be no further discussion or question on the amendment. The chair will call for the question. All in favor of the Lindsay amendment signify by saying aye. Aye. Opposed, like sign. Amendment carries. Any further amendments? There being no further amendments, the chair will call the main question, which is a due pass motion to HB 861, which is LC 352650S, as amended and as a committee substitute. All in favor signify by saying aye. Aye. Opposed, like sign. No. The chair rules the motion carries. There be no further business to come before. Yes, sir. Excuse me.
Procedurally, if we want to do a minority report, we have to go on notice.
You do. You file your minority report. You've stated it. You will file that with the Rules Committee.
Thank you, Mr. Chairman.
Thank you.